in the trial. The blue jury is in court as well now. Good morning, ladies and gentlemen. Good morning. And we're now ready to proceed with the argument phase of the case. And as I've indicated to you throughout the trial, the comments of the attorneys, their comments are not evidence. You've already seen and heard the evidence presented during the trial. And at this point, the lawyers have an opportunity to comment on the evidence. It's called argument, but really it's commentary on the evidence. They discuss the evidence and give you their interpretation of the evidence, but ultimately it's you who are responsible for evaluating the evidence and determining what happened in this particular case. The lawyers at this point will argue their case to you and comment on the evidence that you've already heard. First the prosecution and then the defense. Are people ready to proceed?
Yes, Your Honor.
All right, you may proceed.
Thank you, Your Honor. Counsel. Morning, ladies and gentlemen. It has been my privilege to represent the people of the state of California in this case. And on behalf of the people, I'd like to thank you for your time and your attention in this lengthy trial. It has finally come to that part of the trial where the decision on the defendant's guilt is entrusted to you. What I intend to do is examine the evidence as presented in this courtroom and break it down into 4 different areas. First, I'll discuss the defendant's attitude and treatment of his parents and the relationship they had with their parents for the year preceding the murders. I won't go back to early childhood. I'll confine my comments to the last year. Secondly, I'll be discussing the evidence establishing the defendant's guilt of first-degree murders and conspiracy to commit murder and the special circumstance allegations of multiple murder and lying in wait. As you know, the defendant is charged with murder of his father and his mother in counts 1 and 2, and of conspiracy to commit murder in count 3. Thirdly, I'd like to analyze the defendant's story regarding the events in the week prior to and leading up to the murders and their post-murder activities. And that would be followed by just a brief summation. Because of the length of the trial, I have had to take many notes, and I apologize in advance that I may have to review or turn to my notes during this argument. With regard to the treatment of the defendants, or by the defendants, of their parents for the year prior to the murders. As the crime scene photographs demonstrate that are up on this board, the defendant and his brother viciously and mercilessly attacked their parents on the night of August 20th, 1989. The defense has been no less vicious and merciless to them in this trial. The defense has attempted to place the victims on trial in this case. They have made obscene accusations, misleading claims, and outright lies about their parents, who cannot be here to defend themselves. As most of you know, it's not easy to be a parent. It is, however, easy to criticize. Now, the defense has tried to make both Mr. and Mrs. Menendez out to be monsters. At the same time, the defense has attempted to portray the defendants as helpless children. You have listened to 5 months of testimony in this case, and I'm not going to review all of the testimony presented. It is clear, however, that the defendant and his brother were adults when they conspired to and then murdered their parents on August 20th, 1989. Thus, as I said, I will concentrate primarily on the relationship between the defendants as adults with their parents, Mr. and Mrs. Menendez, starting with the summer of 1988, in order to give a perspective, a backdrop to the murders. In July of 1988, the defendant, Erik Menendez, committed a grand theft from the home of Mr. and Mrs. John List in the Calabasas area. The defendant took money and jewelry from their safe. Later, in July 1988, the defendant, with the assistance of his brother, Lyle, committed a residential burglary of the home of Mr. and Mrs. Ginsburg in the Calabasas area. The defendant stole a safe, jewelry, a computer, china, silverware, and a Solaflex machine, among other things. Later, when these crimes were discovered by Mr. and Mrs. Menendez, that their sons were involved, in September of 1988, Mr. Menendez accompanied the defendant and an attorney to the Los Angeles County Sheriff's Department in Malibu. At that time, some of the stolen property was returned and actually turned over to the sheriff. However, according to defense witness Ed Fenno, Mr. Menendez paid $60,000 to $70,000 back to the families, Ginsburg and List families, and that was for the property not returned. Understandably, Mr. Menendez was unhappy with the defendant for doing these crimes. Now, furthermore, the parents reacted to the defendants committing these crimes, and this is their relationship with the defendants, by requiring them to undergo psychotherapy. With the recent move from Calabasas to Beverly Hills, the defendants ended up going to a Beverly Hills psychotherapist, Dr. Oziel. Now, according to Lyle Menendez in the tape session with Dr. Oziel on December 11th, 1989, that came late in the trial, Lyle Menendez states that Dad cried after the Calabasas issue. Now, this man who the defendants attempt to paint as a monster, Jose Menendez, cried when he learned that his sons were involved in these crimes. The parents sought help for the defendants. They cared about their sons. They might not have been perfect, but they were human beings and they had the right to live. According to defense witness Carlos Beralt, who met Jose Menendez in 1959 and who was the executor of the estate and a very close family relative, he came in and testified for the defense. He testified that Jose was jovial, charming, talented, very intelligent, a great guy to be with. He liked Jose very much. This same Carlos Beralt said that Kitty was charming, fun to be around, active, and energetic. According to Mr. Beralt again, Jose absolutely loved his sons. His life was devoted to educating them in a fashion he thought was best for them. He put pressure on them to be the best and exerted control over them, but he wanted the best for his sons and devoted his time to his sons. He didn't have hobbies. Every minute he had where he wasn't away from work, he spent watching his sons, taking his sons to tournaments. He spent a lot of time with his sons. They meant a lot to him. However, after the Calabasas thefts, and after the defendants were adults, sometime late in 1988, Jose Menendez told Carlos Beralt that he wanted to disinherit the defendants, both Lyle and this defendant. And in June or July of 1989, shortly before the killings, Jose Menendez explained to Carlos Beralt that he was frustrated and disappointed in Lyle and Erik, and again talked to Carlos about disinheriting them. Now, the defendant wants you to view him as a helpless, defenseless child. However, this was a man who was committing crimes which brought anguish and heartache to his father, who caused his father a lot of grief, and his father had a lot of high hopes for both him and his brother. There were problems being caused by the brothers, and the father, I suppose, being at his wit's end, said, I'm going to disinherit you. You understand? Straighten up. Now, in the session of December 11th, 1989, Dr. Oziel states to Erik Menendez, I was there, I remember. I remember when your mom called me and told me that your dad was disinheriting you because he didn't like how you were behaving and that he thought you weren't being respectful enough. And he couldn't tell you because he never talked about feelings. And he wouldn't talk about feelings. And I remember telling you that, and you didn't even look surprised. That must have been what your dad was like then. According to defense witness Pat Anderson, who is the aunt of the defendant screamed "shut up" to his father in front of a crowd of people in the Kalamazoo tournament in August 1989. The defendant told you that he would never do that to his father, never embarrass his father, yet he did that in front of the whole crowd at Kalamazoo. In fact, Pat Anderson said that 10 other games paused for a moment because of the yelling. Now, according to Brian Anderson, the uncle of the defendant, who was also at the Kalamazoo tournament, who also testified in this case, when Jose tried to talk to the defendant after the defendant lost his match in Kalamazoo, he was rebuffed, and Jose was heard to say, "If I can't communicate with you, there's no sense in talking." Brian Anderson said that both the defendant and his brother would talk back to their mother frequently. Lyle would use profane language to both parents. Carlos Buralt acknowledged that, also testified that Lyle disrespected Kitty and would talk back to her. You even heard the coach, Mark Heffernan, testify that when he was there giving the brothers lessons at the Beverly Hills house, he would hear the mother, Kitty, say to the defendants, "Now you have to do this," and he stated that the brothers would then be mad at the mother. Now, according to the defense witness, Ed Fenno, Lyle would not do what his mother asked him to do, and Lyle basically had a go jump in the lake attitude toward his mother. Now, according to Brian Anderson, defendant Erik Menendez would also use profanities toward his mother. Now, these witnesses, both defense and prosecution witnesses, observed the defendants disrespecting their parents in the year before the murders. Yet, this defendant claims that he was afraid of his mother and father. The defendant, who is 6 feet tall, went so far as to claim that his mother was about as tall as Lyle, who is nearly 6 feet tall. Now, the defendant was, I suppose, again attempting to mislead you into believing that she was this huge monster who was to be feared. Now, but 5 foot tall Pat Anderson, the aunt, testified that Kitty was only a bit taller than she. She was not this big monster that this defendant wants you to believe she was. Now, according to the defendant's friend Perry Berman, this was a friend that was attempted to be used as an alibi, but who refused to come to the house on the night of August 20th. He was the one that was supposed to meet with the defendants at the Taste of LA in Santa Monica, and he was a very good friend of the defendants. He testified that Mrs. Menendez was a very sweet, caring woman. Well, while Mr. Menendez was a disciplinarian, he was very strict. Ed Fenno also stated that another friend of the defendants, Ed Fenno, was the one that lived in that Menendez house from about October of '88 until February of '89. Mr. Fenno testified that Mr. Menendez was stern and strict. Now, Mr. Menendez expected the defendants to toe the line. Is evidence from these witnesses that in the year preceding the murders, the defendant and his brother were not intimidated children, but rather were arrogant men who demonstrated disdain for their parents. Now, it is not uncommon for adult children who live with their parents to have disagreements with them. But if you can't abide by the rules laid down by your father, then you can just get out of the house. You can hit the road. Now, this the defendant apparently didn't want to do. Now, with this relationship in mind, and not thinking about what the defense wants you to think about is baby pictures, this is what the relationship was like in the year preceding the killings. With that in mind, I want to turn to the discussion of the crime itself, discussion of premeditation and deliberation and murder. Now, Dr. Oziel testified that on October 31st, 1989, the defendant spoke of seeing a movie on the BBC involving a son murdering his father. As Erik Menendez described it, Lyle came in during the movie. He didn't see the entire movie. And that after this movie, the defendant and his brother Lyle discussed how their father was similar to the father killed in the movie, and that the defendant and Lyle then began to discuss killing their own father. Dr. Oziel testified that the movie was shown a few weeks before the defendants killed their parents. We know through the stipulation that on July 30th and 31st, actually 3 weeks before the murders, NBC aired the Billionaire Boys Club 2-part movie. It aired nationwide, including in Beverly Hills and in Tampa, Florida, the place where the defendant, Erik Menendez, testified he and his brother were on July 31st, 1989. Now, this movie included the killing of the father of one of the young men associated with the Billionaire Boys Club. When I asked the defendant in cross-examination about the BBC movie, the defendant suggested that Dr. Oziel must have meant the British Broadcasting Company. However, I confronted him with the fact that BBC also stands for the Billionaire Boys Club. It was not until the defendant was confronted with a transcript of the taped conversation that this defendant had with Craig Signorelli on November 29th, 1989, that the defendant then he was actually forced to admit that he knows that BBC stands for the Billionaire Boys Club, and was further forced to admit that in that conversation, November 29th, 1989, that the defendant spoke about starting a business corporation like the BBC, like the Billionaire Boys Club, in which he and his friends would make $1 to $2 million and they would get a Rolex watch. Now, the defendant has throughout this trial attempted to lie and to mislead you by suggesting that Dr. Oziel must have meant a movie on the British Broadcasting Company, when he knew full well that the BBC stood for the Billionaire Boys Club. Now, it's understandable why he didn't want you to associate the two, because that would not have looked good for the defendant. You will also recall, I believe, that he first tried to deny that he wanted to be an actor. But as the evidence developed, and as you heard on the December 11th, 1989 tape, he indeed wanted to be an actor. But he couldn't admit that because that would look bad for him too. So unless he's pressed, unless there's something right on tape, he's going to deny it, he's going to lie about it. And even if it's on tape, he's going to come up with another story. Now, as 21 and 18-year-old adults, the defendants discussed getting rid of their own father to be rid of his control and domination and to be rid of the person who prevented them from doing what they wanted to do. They needed to get their father out of their lives. They felt that if their father continued to live, they would have no freedom in their own lives. That's what they told Dr. Oziel. Dr. Oziel testified that the defendants said that they decided to kill their father, but the decision to kill their mother was harder for them to decide. As you heard the language of Lyle Menendez, it was a harder issue. A harder issue. Killing your mother is an issue. The December 11th, 1989 tape confirms and supports Dr. Oziel's testimony here. Now, Dr. Oziel was attacked viciously in this trial. He was attacked. People were brought in to say bad things about him. But in the final analysis, the defendants admitted most of what he testified to. And in fact, the December 11th, 1989 tape also confirms what Dr. Oziel testified to. Referring to the December 11th tape then, this is the brothers' voices, their own voices. When you have information, you have a witness that gives information against the defendant, of course they're going to attack the credibility of that witness. Then when you have a tape of their voices, they've got to put some kind of spin on it. They've got to explain it somehow, and that's what they will probably attempt to do later today. Now, with regard to that tape and the transcript of that December 11th tape, at page 5, Erik Menendez is heard to say, "Never could she," that is the mother, "live without my father." And what they're doing is they're talking about the decision to kill the mother also. They already decided they're going to kill the father, but the decision had to be made what to do with the mother. At page 6, Lyle, again on this issue, Lyle states, "That was something that we had to really, it was a big thing holding us back from killing my father, was that we thought we would just kill Dad and eliminate the problem." And then later on, Lyle Menendez at page 17 states, "My father should be killed, there's no question." At page 20, Lyle continues, "So it came down to that decision, and we decided that my mother could not live without my father." And then at page 21, Lyle states, "And it was just a question of Erik and I getting together and someone bringing it up and us realizing the value in it." At page 31, Erik Menendez states, "My mother had to be killed. It was the only way out for her." These defendants knew that they were being taped that day. They tried to put the best spin on what they did by saying that they were doing their mother a favor because she was suicidal. As Julon Smith indicated, they were told to try to seem remorseful because someday maybe a jury would hear this tape. On that same transcript, page 42, Lyle Menendez states, "There was no way I was going to make a decision to kill my mother without Erik's consent. I didn't even want to influence him in that issue. I just let him sleep on it for a couple of days. It had to be his own personal issue. If he felt the same way I did about killing Mom." Well, they thought about it for a few days and they decided that she would die too. The decision was made to kill both parents. An agreement was made, and as Lyle Menendez indicated on page 46 of the December 11th, 1989 session, we had to go down wherever to take care of an important issue concerning it. This, I believe, is a clear reference to having to travel down to San Diego to get the guns, an overt act in furtherance of the conspiracy that had been formed. Now, we know that the defendants drove to San Diego and bought 2 shotguns using fake ID and a fake address. Their story is completely ludicrous, that they just happened to be driving down the 405 and heck, they ended up in San Diego, and well, good place to buy the shotguns. Now, they used fake ID, they used a fake address on top of that. Now, although we know that Lyle Menendez usually used a credit card to make purchases, on August 18th, 1989, before the defendants left their Beverly Hills house, they got cash to make the purchase. But the defendants will tell you that they weren't trying to hide what they were doing. Well, why did they take cash? If they had made all these purchases on credit cards all that time, why on this occasion did they have to get their cash? Because by paying cash and using a false name and using a false address, you're not going to get caught. You're not going to be connected to the crime and the guns, the type of guns used to kill your parents. While in San Diego, the defendants also purchased shotgun ammunition. Now, with the guns having been purchased, the defendants waited for an opportune time to kill their parents. They had purchased the shotguns, as we know, on Friday night, August 18th, 1989. But there was yet to develop the alibi and to refine it. Now, with the maid gone on the weekends, that Flor Surya, who came in and testified, with Miss Surya gone on the weekends, there would be no witnesses if they did it on the weekend. Saturday, we know that the Menendez family went shark fishing, and on Sunday, August 20th, 1989, Lyle Menendez called his friend Perry Berman to arrange to meet Perry that night. Berman told Lyle that he was going to the Taste of L.A., and Lyle told Berman that he and the defendant were going to the movies and would meet up with Berman at the Taste of L.A. after the movie. Now, the defendants had decided to use the alibi that they were at the movies during the murders, and they went to the Taste of L.A. actually afterwards. Now, that's the story that they gave. That's the story that they gave that night to Sergeant Edmonds. In fact, according to Perry Berman, while Lyle called him at home, because Perry Berman waited for them, but had to go home, at about 11:07 p.m., he received a call from Lyle Menendez. Lyle stated that he was at the Taste of L.A. in Santa Monica. Lyle claimed, always thinking, that he and Erik had been there at the Taste of L.A. since 10:15, the approximate time of the killings. And they couldn't find Perry. Lyle asked Perry to meet them at their house that night, that he had to see Perry that night. Lyle testified that, well, he just needed a friend. What he needed is a friend to be there so that that friend could be there when they walked in to, quote, discover, unquote, their parents. It would be a little tidier if they knew that they were going to call the 911 operator themselves and come upon the scene themselves. But it would have been nicer, I suppose, Lyle felt, that if he had a friend there, they could all go in there and make this discovery. Much to the defendant's dismay, however, Perry Berman didn't bite. He said, I got to go work tomorrow. I'll meet you at the Cheesecake Factory, but I'm not going to come all the way to your house. Now, the defendant told Dr. Oziel that there was no way to connect them to the murders. Erik Menendez said he walked into the family room first and Lyle followed. They, quote, surprised, unquote, their parents. Dad said no, 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 and Mom was moaning and did not die immediately. Even after emptying their shotguns into their parents, she was on the floor moaning, crawling, and trying to move. Erik and Lyle Menendez went back to the car to get more ammunition and walked back into the house to finish murdering their mother. The defendant further told Dr. Oziel that they picked up the shotgun shells, exited the house, took all their bloody clothes, put on new clothes, threw their bloody clothes into a dumpster, and took their shotguns 150 feet down an embankment over Mulholland Drive, covered them up, and then drove to the wine tasting party. These are the things that Dr. Oziel testified to. They later returned home and acted as though they were the grieving sons, having stumbled upon the bodies of their parents. And they then made the 9/11 call. The defendant indicated and felt that there was no way to connect them to the murders. Erik said that there was no way to link them since the fingerprints in the house would be there since they lived there. No witnesses. No one could link them in any way to the weapons because the weapons he himself had buried. And Erik believed that there was no way to tie them into buying the weapons in San Diego. So there was no way to link them to the murder except now that Erik had spoken to Dr. Oziel. Dr. Oziel, after getting the information from Erik Menendez in that October 31st session, was concerned. He asked if Lyle knew that Erik was going to confess. And he wanted Erik's permission to confront Lyle personally to assess his reaction, to see if he would maybe be in danger with this information, since there was no other way to connect them except for the statement that was made to Dr. Oziel. As we know, Lyle Menendez came in to the session, that he was immediately extremely concerned and menacing. According to Dr. Oziel, he got mad at Erik for telling. Lyle couldn't believe that Erik would tell Dr. Oziel and not tell him first. Lyle told Erik how stupid he was for telling. Now there was someone who knew. Now it wasn't a perfect murder anymore. Lyle said how could they be sure that Dr. Oziel wouldn't disclose the information that would allow them to be convicted. Lyle said he didn't want anybody looking over his shoulder and controlling him, and that's why he murdered his parents. Lyle stated that having Dr. Oziel know this information caused him a lot of concern. Now, just as Erik Menendez bragged to Dr. Oziel about how good a job they had done and how perfect it was, in a taped conversation of the defendant, Erik Menendez, with his friend Craig Signorelli on November 29th, 1989, and you were able to, in testimony, get parts of the transcript from that particular conversation, the defendant states confidently, "I've known from the beginning, no clues, no one heard anything. Man, we're talking about special hitmen, special shotguns, and knew exactly what they were doing in and out of that house. No one saw anything, no one heard anything. We're talking serious hitmen." He was proud of how they had done it. They had done a perfect murder, they thought. The defendant testified that he and his brother didn't know what his parents were doing in the room that they bursted into on the night of August 20th, 1989. Erik Menendez would have you believe that he saw some figures in the room, and he started to fire his shotgun. We know that they had already decided that they would kill their parents. We know that they knew their parents were in there, and we know further that Craig Signorelli testified as to statements made by Erik Menendez regarding what he saw that night. Now, the defendants, supposedly having never shot shotguns before and acting in a panic and indeed a snail-like fear, were actually deadly accurate for shooting into what the defendant claimed was haze and smoke. Mrs. Menendez sustained 10 shotgun wounds and Mr. Menendez 5, with only 2 misses which ripped through the shutters of the French doors which were immediately behind the victims. Now, according to Craig Signorelli, and the defendant admitted that he did talk to Craig Signorelli. According to Mr. Signorelli, on September 1st, 1989, the day the computer man and his pregnant wife were at the house, the defendant told him that he and his brother went to the movies and then went home to pick up the defendant's fake ID. That Lyle got the guns and said, "Let's do it." that Erik and Lyle went to the family room, and the defendant was on the left and his brother Lyle was on the right. That the defendant looked into the room and saw his parents sitting on the couch. That's in the TV room. That the defendant was supposed to shoot his mother and Lyle was supposed to shoot his father. That Lyle then swung open the door and shot his father, and Erik said he shot his mother as she was standing up yelling. Now, according to witness Catalani from the LA County Sheriff's Criminalistics Laboratory, he found blood on the bottom of Mrs. Menendez's shoe, indicating she, at some point, was probably standing upright before she succumbed to the hideous onslaught that her sons were administering on her and her husband. Now, Craig Signorelli's testimony is very significant because it shows that the defendant, one, looked into the room and saw his parents on the couch before he and his brother burst into the room, catching them by surprise. And it also shows the planning of the defendants because it shows and is consistent with the statements made to Dr. Ozio and the December 11th tape. It shows that the defendants had decided among themselves who would shoot who. It also contradicts the defendant's story that he couldn't see anything and was acting on autopilot and in a robot-like state. Now, because of this, the defense went at Craig Signorelli very aggressively, throwing out 3 defense witnesses to try to take the sting out of Signorelli's testimony. They threw out Kevin Whalen, the so-called devil's advocate, who testified that Craig Signorelli couldn't have been with the defendant on September 1st, 1989, because it was he, Kevin Whalen, who was with the defendant on September 1st, 1989, because he picked the defendant up on that date at LAX when the defendant came back from the East Coast. And he remembered that date specifically, and he remembered going to the house, and Erik had listened to his answer machine, and Erik kept his luggage in the car, and then they went home and they had dinner with Kevin's mother that night, and they talked about the computer man who was there that day, the day that Kevin Whalen picked him up. Well, Kevin Whalen testified he didn't remember any pregnant wife, but he remembered a computer man there the day he picked Erik up from the airport. We heard Kevin's mother, Mrs. Bulow Cohen, and also Kevin's sister was called by the defense, Catherine Whalen. They all 3 testified for the defense that Kevin picked the defendant up from the airport on September 1st, 1989. They remember that date. Now, Kevin stated that he doesn't remember the day after the day that he picked up Erik Menendez from the airport, however. Now, the defendant himself testified that he came back from the East Coast on the day the computer man came with a pregnant wife to the Beverly Hills house. So there were 4 witnesses that were delegated with the duty of trying to somehow impeach, contradict Craig Signorelli. We know that the computer man himself, Ed Heyman, and his wife also testified here. She was a pregnant lady then. They both testified that it was Craig Signorelli that was there on that day. Yet, these defense witnesses tried to say that the Heymans were off their rocker, they didn't know what they were talking about, that Craig Signorelli wasn't there. They said the whole Whalen clan basically said some not nice things about Craig Signorelli. Mr. and Mrs. Heyman, the computer people, did not ask to be witnesses in this trial. They just happened to be experts called to perform services that day. Nevertheless, both of them, or all 3 of them, were attacked, and the defense was trying to show that Craig Signorelli basically was not there on September 1st because, as I've indicated, Craig Signorelli's testimony is significant in the ways I've noted. Now, when you think about it, how do you show when a person came back on a plane ride, when he came back? Do you go to all the different airlines and have them check and see? Well, after hours of research and review, evidence was in fact uncovered that Erik Menendez did not come back on September 1st, as he testified and as 3 witnesses testified. He came back on August 31st, 1989. He came back from LaGuardia Airport to LAX. And we know that because we know that through the testimony of Pat Heffernan, who was Coach Mark Heffernan's wife, who saw the defendant in New York at the Sheraton, who let Erik Menendez use her American Express card to make the purchase on U.S. Air. And we also brought in Carol Black from U.S. Air, who testified to certain documents from that company, U.S. Air, indicating that indeed Erik Menendez had flown back on August 31st to Los Angeles. And that is Exhibit 292. So this exhibit, it's a small exhibit, but it's very significant for the ways that I've indicated. Exhibit 400 is another piece of the U.S. Air information, and that is an American Express gold card receipt belonging to the Heffernan, showing that Erik Menendez's ticket was in fact purchased relevant to the New York to Los Angeles plane flight. So those are exhibits 292 and 400. Now it's clear that Mr. Heyman and his wife were not mistaken, that in fact the Whalen clan was mistaken, and one would hope that embarrassment prevails in the Whalen home for trying to attack Craig Signorelli and the Heymans in the way they did. We know that the defendant told Dr. Oziel that the defendant surprised their parents and that their mother kept moaning and moving, so they had to reload to finally kill her. That's what Dr. Oziel was told. And in fact, the defendants had to admit that because there were too many shots. I mean, they fired too many shots. They had to reload. They had to acknowledge that they reloaded. In fact, Erik Menendez said that his mother was moaning, so they had to go back out and reload. The evidence shows that Mr. and Mrs. Menendez were sitting on the couch watching TV when they were surprised by the defendants and shotgunned to death. Lyle testified that he put a shotgun up to his father's head, and it was he who put his shotgun also up to his mother's cheek and delivered the contact wound blasts to them. According to their statements on December 11th, 1989, and in that tape, the defendants had decided to kill both parents. Clearly, when they entered that room, that family room, on August 20th, 1989, they intended to kill their parents. The defense may attempt to argue otherwise, but it's clear from the evidence that they intended to kill their parents. They fired their pump shotguns into their parents, and in fact, the defendant testified that after he and Lyle emptied their shotguns, they ran out to the car, and the defendant, without even talking to his brother, knowing or knew, and testified that he knew, that Lyle would return to the room to kill their mother, because they already planned that this is what they were going to do. And her laying there moaning, that wasn't going to cut it. She might survive. They knew they had to kill both parents. So what does Erik Menendez do? He says one cartridge to his brother with which to deal that fatal blow to his mother and stop her from the possibility of her surviving the attack. Clearly, the defendant intended to assist in the killing of his parents. Now, Dr. Oziel, Craig Signorelli, and statements made by the defendants from their own mouths on December 11th, 1989, statements that they'll try to put a spin on, but they're in their own voices, establish that the defendants clearly intended to kill their parents, and indeed, they made sure that the parents would not survive the shotgun attack by administering contact wound blasts. So if you look at the crime scene and you look at what they did, it's clear what their intent was. They weren't going to leave any survivors. fact, you've had testimony that these photographs indicate that there was UCLA paperwork, blood spattered next to the mother. There are no weapons next to the parents. In fact, Kitty Menendez's friend came in and testified, Karen Farrell, and she said that they had planned to play bridge with Mr. and Mrs. Menendez that night. There was no plan to kill the defendants as they have attempted to claim. Judalon Smith. Judalon Smith testified that she heard Lau yelling at Erik in Dr. Oziel's office, and she confirms that Dr. Oziel called his wife to warn her, a psychologist, a lawyer, and also a police station for advice. Does this sound like something that a man would do that's been threatened? Now, Dr. Oziel indeed justifiably felt threatened by the brothers, and indeed the courts have ruled that the exception applied to the October 31st and November 2nd sessions, allowing Dr. Oziel to testify as to those sessions.
All right. Judge sustains that portion of the remarks regarding any court rulings. The jury's admonished to disregard it. You may proceed with your argument.
Dr. Oziel wanted to get the defendants on tape, as Judalon Smith indicated. And why did he want to do that? He wanted to do that, as she testified, for his protection. That if you get him on tape, he had told them he had him on tape for his protection. He had an insurance policy that don't do anything to me because I've given these tapes to my lawyers, and if I get killed, you're going to be found out. Dr. Oziel wanted their voices on the tape. Now, Dr. Oziel, according to Judalon Smith, had told the defendants that they would be recorded for their own benefit if they ever get caught. He indicated that they should show remorse on this tape. And Dr. Oziel really wanted it to protect himself and Judalon. Judalon testified. Protection from the defendants. Now, after the defendants were finally put on tape, Dr. Oziel felt somewhat relieved. He had a pretty good insurance policy at that point. Now, does it sound consistent that a helpless, poor, abused set of brothers would threaten their psychotherapist who found out about the killings? Or does it sound more consistent with cold-blooded killers? With regard to Judalon Smith, there was testimony about an affidavit that she submitted to the Superior Court in Santa Monica. And at page 21-234, part of that affidavit was testified about. And what it stated, and this is an excerpt from that affidavit, signed under penalty of perjury by Judalon Smith. I was also particularly concerned because after hearing Lyle threaten, now we have to kill him and anyone connected to him who knows we're connected to him, end of quote. I had heard the threat to include references to the secretary because there's a secretary that you go through to make appointments. Further, regarding that same affidavit, at page 21,237, this appears to be at page 18 and 19 of that affidavit by Judalon Smith, planned to kill their mother and father as they were themselves watching TV at home. So this goes to what the judge will later instruct you about lying in wait, that they planned for an opportune time to act. They come in and surprise their parents, and there was a period of watchful waiting which preceded the killings. Now the affidavit continues, and it's testified further at 21,238. The father either died instantly or quickly, more so than the mother, because they described the mother as continuing to move or gasp and make sounds, and that they had to just really keep shooting and shooting her. Well, yeah, they did have to keep shooting her, and we know that she had 10 wounds on her. She wasn't standing still for them to get to a vital area. She was getting blasted all over that room. And when she finally got to where she was laying on the ground moaning, that's when they put that final blow into her. So indeed, when she indicates that the mother kept moving and they had to keep shooting her and shooting her, that's borne out by the evidence. Julon Smith was also examined by Mrs. Bozanich regarding the Diane Sawyer, that primetime segment that she did. She was asked, and this is at page 21,154, she was asked by Diane Sawyer, are Lyle and Erik Menendez guilty? Did they murder their parents? Julon Smith says, yes, they did. Diane Sawyer says, you know this? Julon Smith answered, absolutely. I heard from their own mouths that they killed their parents. And then it goes on. Were they proud of it? Julon Smith stated, absolutely. They felt they had committed the perfect crime. One of the things, and this is Julon Smith again, further in the program. This is the Diane Sawyer primetime program, by the way. And this is at the bottom of 21,154 and it goes on to 21,155. Julon Smith states, one of the things that I heard Lyle say that was really disturbing to me, this is a sum of and the essence of what he had said. Well, for once my father would have to congratulate me and give me credit that I planned the perfect murder. I carried out the perfect murder. With regard to Julon Smith, there's testimony that she had testified under penalty of perjury in front of Judge Albrecht in the Superior Court of Los Angeles in Santa Monica. And that testimony is reflected in pages 21,159 through 21,164. And part of that testimony was Julon Smith acknowledging that she testified under oath in front of Judge Albrecht on July 30th of 1990. And in that case, certain hearings were being held in Santa Monica, and there was a question by the court, that is Judge Albrecht, of Ms. Julon Smith. At some point, did you learn of there allegedly being threats from the Menendez brothers to Dr. Oziel? And after some exchange, the answer was, I directly heard them make the threats. The judge then asked, do you recall the date on which you first heard such a threat? Julon Smith's answer was the night of October 31st, 1989. The judge then asked the question, and where did that occur? Julon Smith answered, at 435 North Bedford, the offices of Jerry Oziel. The judge, Judge Albrecht, then asked, and at whom were those threats directed? The answer by Julon Smith, to Jerry Oziel. The question by the judge, and could you tell who was making the threats? The answer by Julon Smith, yes. She goes on to state that the threats were made and she could hear from inside the room where the defendants were with Dr. Oziel. She goes on to state at 21,164 that all there was separating her from the two defendants and Dr. Oziel was the door. And she could hear, the judge asked, Judge Albrecht asked, could you hear clearly through the door? Julon Smith answered yes. Questioned by the judge, could you hear people in the other room if they were talking in a normal tone of voice? The answer by Julon Smith, from the other side of the door, yes. Judge Albrecht then asked, could you tell who made the first threat? Julon Smith said yes. She was then asked by the judge, by what means could you tell? Julon Smith answered, by the context of the conversation. The next question asked by Judge Albrecht was, do you want to tell me a little bit more about that? How you arrived at that conclusion that the threats were being made? The answer by Julon Smith was, well, because Lyle was angry at Erik for telling Jerry, for coming to tell Jerry about his parents. He yelled and said he didn't have a brother anymore. He could kill him. Look at all the trouble he had caused, and now he'd have to kill Oziel and everybody connected to Oziel and everybody who knew. That's how Julian Smith testified in front of Judge Albrecht in 1990. And as I've indicated, there was an excerpt from the affidavit submitted under penalty of perjury by Julian Smith. Now, we know that the defense called Julian Smith in to testify. We know that there was a lot of acrimony between Julian Smith and Dr. Oziel. And we know she now has different memories, but this is how she testified in 1990. There is a lot of evidence about the defendant's desire to kill his father. The defendant, in his testimony, said that his father told him what he would do and be in life, what he would do in sports, what he would do as work. Mr. Menendez put pressure on the defendant. The defendant didn't like that pressure. Mr. Menendez even had plans for Erik and Lyle to move to Florida to live in a family compound, kind of like the Kennedys. Now, Erik Menendez told you in his testimony that he was told that he was out of the will in September of 1988, which coincidentally occurred about the same time that Mr. Menendez was accompanied Erik Menendez to the Los Angeles County Sheriff's Department in Malibu about those burglaries, or the burglary and grand theft that Erik Menendez had committed. Of course, Erik Menendez said, well, that really didn't have much to do with my being disinherited. It was because I dropped in my rankings in tennis. You also heard Erik Menendez say that in May of 1989 that his father wanted to disown him. Erik feared, all right, he feared that he would have to get off of his butt and work just like all the rest of us. And his father was going to cut him off and just say, you know, if you can't abide by my rules, then you can go ahead and live on your own. Erik obviously didn't want to get kicked out. In fact, he said he didn't want to get kicked out. He didn't want to get disowned. But he didn't want to do what his father had as far as the rules of the family. He didn't want to toe the line. And as he testified, he said that things were changing. And in cross-examination, he said his father was starting to cut off Erik and Lyle. He was starting, and they were adults. You know, there's a time at which you have to go away from your parents. I mean, there's a time at which if you're going to be an adult and live with your family, with your parents, you can't just have your own rules. And if you don't want to abide by them, then you shouldn't be there. The defendant continues with this sentiment in the December 11th tape. At page 1, the defendant starts out, it starts the tape off. The defendant, Erik Menendez, states, "Yet we thought that no matter what we did in our life, my father would be there, and that it," unintelligible, related to Kennedy. When Kennedy was president, his father told him that he wanted Bobby in this position, and it did not matter what John said. And we thought that whether we became the senator or whether we made hundreds of millions of dollars, it would all be because my father was this incredible man and we were just, the word is either pushed or privileged. Erik Menendez goes on to say, and the pressures, and there was no question about that. What the defendant is saying that his father would always be calling his shots. It didn't matter if he were to become the president or a senator of the U.S., that his father was there, he would push him, he would tell them what to do, and the defendant didn't want that pressure anymore. He didn't want to have to put up with his father anymore. Also on the December 11th, 1989 tape, the defendant responds to Dr. Oziel's observation that Erik was about to go to college. Erik Menendez responds, by going to college, I mean, it didn't matter. Even if I was in college. I remember when I was in college, I wanted to major in theater. And my mom wanted me to major in theater. But couldn't tell me that because she was an actress, and she was a great actress. And so she had this love for theater. And when she saw me at stage when I was at Beverly, she loved it. And she wanted me to major in it. But I couldn't even bring it up to my father. I did once, and it was he thought I was kidding. It wasn't even something that was going to even be brought up, and my mom certainly would never bring it up. And so what I was doing, what I was taking, I wasn't even going to decide. It was my courses. When I had an hour or two to select my courses, I would already have the sheet and already have it worked out, and my dad would already have worked out what I was going to take. So what Erik Menendez is saying that is he felt that he had to get out of the control of his father. His father just made all the decisions, even on what he was going to take in college, where he was going to live later, who we'd live with. The decision then was made to kill both parents, and that is reflected on this December 11th tape. But that is a choice that the defendants made, and they're going to be held, they should be held responsible for making that choice.
All right, are you moving on to another subject?
Yes, I have another section that I was going to start on.
What we'll do is take our recess at this point, and we'll resume at 20 minutes to the hour. Ladies and gentlemen, don't discuss the matter with anyone, don't form any final opinions about it, and we'll resume at 20 minutes to the hour.
At this point, I'd just like to go over a couple of jury instructions. The judge will instruct you on the law at the close of arguments. And as you know, you're the judges of the facts. But with respect to the law of murder, the judge will instruct you consistent with what is here, and that is the elements to be proved in a murder. The first element is that a human being was killed. The second, the killing was unlawful. And the third, the killing was done with malice aforethought. Clearly, the first, Jose and Kitty Menendez, it's clear that that element is established. With respect to the killing, there will be no claim that this was a lawful killing. And with respect to number 3, malice aforethought, the judge will instruct you what the definition of malice aforethought is. And for express malice, malice is expressed when there is a manifested an intention unlawfully to kill a human being. So when it's an intention to kill. So to show malice aforethought is a simple matter of showing an intent to kill. You'll be instructed with respect to malice aforethought, the mental state constituting malice aforethought does not necessarily require any ill will or hatred of the person killed. The word aforethought does not imply deliberation or the lapse of considerable time. It only means that the required mental state must precede rather than follow the act. That is, the intention to kill. With respect to the charges in this case, the defendant is charged with 2 counts of murder of Mr. and Mrs. Menendez. But in order to affix the degree of the murder, it's relevant to, and the judge will instruct you on deliberate and premeditated murder. And that is, or will be defined as all murder which is perpetrated by any kind of willful, deliberate, and premeditated killing with express malice aforethought is murder in the first degree. The word willful, as used in this instruction, means intentional. The word deliberate means formed or arrived at or determined upon as a result of careful thought and weighing of considerations for and against the proposed course of action. The word premeditated means considered beforehand. To constitute a deliberate and premeditated killing, the slayer must weigh and consider the question of killing and the reasons for and against such choice, and having in mind the consequences, he decides to and does kill. As we have reviewed the evidence, the defendants weighed their decision to kill. They spoke about the considerations to be made after watching the Billionaire Boys Club. They talked about killing their father. They came to the decision that they would kill their father. They had to discuss, as they indicated on the December 11th tape, further discussions about whether or not they would kill the mother as well. So there were these discussions taking place which you can consider to be they're premeditating and deliberating over whether or not they were going to kill their parents. There's another instruction. There's two special circumstances alleged. One is multiple murder, and that's a simple instruction. That is, if you find murder, and at least one of the murder counts is first degree, then the multiple murder special circumstance applies. And you'll find that to be true then. With respect to the lying in wait special circumstance, there will be given a rather lengthy instruction on lying in wait. In part, you will be instructed that lying in wait is defined as waiting and watching for an opportune time to act, either a concealment by ambush or some other secret design to take the other person by surprise. When a defendant intentionally murders another person under circumstances which include concealment of purpose, a substantial period of waiting and watching for an opportune time to act, and immediately thereafter a surprise attack on the unsuspecting victim from a position of advantage, the special circumstance of murder while lying in wait has been established. You'll be instructed about all the law in this case. Not all of it may be applicable, but you'll be instructed by the judge later in this case. I think those are the instructions that will be dispositive in this case. Next, I'd like to turn to an analysis of the defendant's story regarding the events of the week prior to the murders. That is, what did they claim led up to this, the killing? First of all, the defendants claim that on August 15th, 1989, it was a Tuesday, Kitty Menendez pulls off Lyle's wig and makes him cry. There's a big argument with yelling and screaming, and the defendant, for the first time, learns of his brother's wig, and as he testified, he decides to share a moment with his brother and tells his brother about the molestation. What we have in that regard is, first of all, they never told the story to anybody until you heard it here. I mean, they didn't tell the story to the police when they were arrested. The story didn't come out to any of the newspaper people that they lied to, the relatives that they lied to.
Overall.
What, in the analysis of that particular part of their story, their version, the people put on Jamie Pisarcik, who testified that the defendant knew about the wig before the murders. She believed in the spring of 1989. Ms. Pisarcik, when pressed, remembered seeing Hurly-Burly at the Westwood Playhouse. She believes during her stay, when Erik says that told her that he knew about the wig. Well, we know through the stipulation that Hurly-Burly in fact played there at the Westwood Theater from November of 1988 to January of 1989. We know that Flor Surya, the maid, didn't hear of any such screaming or yelling, and she was there on August 15th, 1989. The next part of their story of the week preceding the murders was August 17th, 1989. The story is that Lyle confronted Jose about molesting Erik. Jose says he will do what he wants, and late at night, Jose attacks Erik and bangs on Erik's door, yells at Erik, tries to molest Erik. Erik escapes the struggle, and he indicated he really got into this story. He was saying that the typewriter flew off the desk, and there was a big rigmarole, and he was thrown on the bed. And then he goes downstairs, and his mother happens to be sitting in the TV room. So he happens to just have a chat with her. He discusses with his mother his problems. She says she knows. Erik says, "I hate you." After first she asks, "What's wrong with you?" Mother says, "You bastard." There's yelling. And this, as you know, is in the room right next to where Flor Surya is staying. She's sleeping. This was on a Thursday night. She didn't leave until Friday. Of course, the defense brought in witnesses and say, "Well, I didn't hear yelling and screaming. Mr. Slotkin, I didn't hear yelling and screaming." But on cross-examination, he said, "Well, there wasn't yelling and screaming in my house, so I guess I wouldn't know whether there was yelling and screaming." Flor Surya, who actually lived in that maid's room, testified that she could hear the television from the next room over, the TV room, which is right next to her room. And this is where supposedly this yelling was occurring. In fact, Lyle Menendez testified that he could hear the yelling and screaming from the guest house. And from those photographs, you can see how far a distance it is from the rear of the house. You have to go past the tennis courts and the pool to get to his guest house. So there must have been, according to them, some really loud yelling and screaming. Yet she heard none of that. The next leg of this story that they made up is that on August 18th, the defendants get up early, they get their cash together, they go to the Santa Monica Big Five to buy handguns. The defendant claims to have been directed to the real handguns, and he and Lyle select a real handgun. And when ready to make their purchase, they are informed that they cannot leave the store with the handguns because of the 2-week waiting period. Well, we know first of all that Mark Heffernan, the coach, testified that he gave Erik a lesson, a tennis lesson that morning on Friday, August 18th, from either 9 to 11 or 9:30 to 11:30. And you know from Erik's testimony, he went early in the morning, and he was there at this Big Five store in Santa Monica that morning. We know further that Big Five does not carry handguns and haven't since March 1986. But of course, Erik Menendez tries to weasel out of this lie too. What does he do? This happens on a Friday, the testimony about the Big Five and him getting caught in that lie. And of course, he has time on the weekend to think about this, and he comes back on Monday, and he starts to say, well, you're the one that says, as I'm cross-examining him, you're the one that says it's a Big Five. And I said, you're the one that said it was a Big Five. Not only did he testify it was a Big Five, his brother testified it was a Big Five. In fact, his own attorney came back and said, are you sure you're at the Big Five? Oh, positive on the Big Five. No question about it. Well, the defendant comes back, and they put on some fancy photographs, a series of photographs. They bring in a couple of witnesses. To say what? To say that there were guns there? No. They didn't say that, but they have to bring some people in to kind of confuse things for you. So it's clear that there were no handguns in Santa Monica at the Big Five store that day. But what the defense then tried to do to weasel out of this one is, upon being questioned by Mrs. Abramson, Erik Menendez is asked, well, was the clerk kind of helping other people? Maybe it was the clerk's fault that he thought that there were real handguns there. Maybe he misled this poor defendant. You know, maybe it's the clerk's fault. Clearly, Mark Heffernan remembered that lesson that morning, and they weren't at the Big Five store in Santa Monica trying to purchase these handguns. The fourth leg of this fantasy is on Saturday, August 19th, 1989. The defendants get up, according to them, and they leave the Beverly Hills house, and they are shaking in their boots. They leave the house because they're afraid their parents are going to kill them. What they do is they leave, and they're gone the whole day, but what do? They come back, and they're supposed to go to the fishing trip, and they're thinking, oh, well, maybe if we stay out long enough this whole day, our parents will go, and then we won't have to go shark fishing with them. Because, heck, we wouldn't want to get killed on that fishing trip. Well, they come back, they say they're gone the whole day, and they come back, and their parents are coming out to go on the fishing trip. About 4 o'clock, 4:30. Well, we know from the pool man who came in and testified. The pool man, actually the repairman who was just there that one day, he worked on the heater. His name's Grant Walker. Grant Walker is sure he was there on Saturday, August 19th, 1989 at the Menendez house. In fact, the regular pool guy who serviced the pool, Leon Bartek, he was the regular serviceman, is the one that asked Mr. Walker to do the service. So it's not like Mr. Walker came in off the street to say, hey, I was there that day, and I saw them being abusive and cussing in front of their parents and all that. This man was there. He was working on their pool. And that's what the evidence shows. And what he says, what Mr. Walker says, is that he saw the defendants at the house in the afternoon on Saturday, August 19th, 1989. And their story is they were gone the whole day because they were so afraid that their parents were going to murder them. At about 2 o'clock in the afternoon, the defendants, Lyle is on the tennis court, Eric's next to his parents. Defendants are using profanities in the presence of the parents. Walker is so disgusted, he tells his wife how disrespectful the defendants were to their parents. Now, the defense tried to impeach Mr. Walker by calling one of his customers, Mrs. Valdry. Well, Mrs. Valdry corroborates Mr. Walker about being a customer of his and establishes further that Mr. Walker was correct when he said that he serviced her pool on Saturday. Now, she says that he started in 1987, that for about 2 or 3 weeks or so, he had to work with the chemicals, and he was coming during the week. But after that, she said, he came on Saturdays. Well, the defense, what did they do with that? They're the ones that called this witness. Well, they tried to say that she didn't know when this man came. They brought in their defense investigator, and the defense attacks Mrs. Valdry and claiming that she's angry at them. That's why she lied. Well, she didn't lie. She said that she never told the defense investigator what the defense investigator testified to you. Who has any reason? I mean, would Mrs. Valdry have a reason to come in here and lie to you about that? You'll make that determination. Furthermore, with respect to Mr. Walker's testimony, Mr. Heffernan, the coach, corroborated the fact that the parents would pull chairs, although he had never seen the table in that area between the pool and the tennis court. But Mr. Heffernan said, yeah, the parents would bring the chairs over and watch the brothers play tennis. And that the defendants, would cuss on the court. And Heffernan testified earlier. He came back a couple times in this trial. He had testified that the defendants were big, strong, aggressive athletes. These guys were not young kids. Now, the question is, how would Grant Walker know all of this unless he was there and saw it? He was there one day. How would he know that the parents, on occasion, would bring the chairs over and watch their sons? Unless it happened, unless he was actually there. Nevertheless, when a witness testifies and the defense believes it may be damaging, they're going to attack that witness. And in fact, they did that to Mrs. Valdry when she substantiated what Mr. Walker had said by saying that she was angry with the defense. And we know that once the people got the report, in fact, Cindy Early, the defense investigator, had in her notes that Mrs. Valdry was a cooperative witness, not angry as they tried to claim. Next, I'd like to turn to the post-crime, the post-murder driving situation that the defendants testified to. Now, the defendants claimed that, they didn't think about this, they didn't plan this all out. In fact, after they massacred their parents, they sat around waiting for the police to come, twiddling their thumbs. In fact, Lyle testified that they sat there for 5 to 10 minutes waiting for the police, and then, heck, they got tired of waiting, and they started to discuss among themselves. Hey, maybe we can get away with this. So they had a discussion for a couple minutes, then they decided to pick up the shells. They picked up the shells, that was another minute. So let's go over what the defense says about this, what happened during that period of time. Now, first of all, the defense put forth 2 routes, one route being travel to Mulholland, and then after Mulholland down to the theaters, and then to the Santa Monica Taste of LA. Well, neither brother testified to that. Lyle testified that he thinks that they went to the theaters first and then to Mulholland. In fact, Erik Menendez testified that they went to the theaters first, then to Mulholland, then to Santa Monica. So the relevant one would be Route 2. And it was marked as an exhibit testified to by defense investigator Erdely. That would be exhibit number 358A. What we have and what this shows is that there was a lot of speeding going on to try to come in within this time. And there's an overall time of 50 minutes. So giving the defendants the benefit of saying that the murders occurred at 10 o'clock and the call to Perry Berman occurred at 11:07, that gives 67 minutes. So what we then have is, for example, the defense in this Route 2, an overall time of 50 minutes. That is driving time from the Beverly Hills house to the theaters, to Mulholland, and then to Santa Monica. For example, defense investigator Erdely was going 40 to 45 in 25-mile zone on Coldwater, et cetera, et cetera. You can take a look at the exhibit. So they try to make it, try to go pretty fast to try to make it so they could fit within that time. But if you look at Lyle Menendez's testimony, and you look at the time allotted by the defense in this exhibit, what they call activity time allowances. And when Ms. Erdely testified, she said, well, I didn't really have the testimony. Mrs. Abramson told me what times to plug in. Okay, so let's see what times she was ordered to plug in. There's an overall time of 4 minutes for after the shooting. This period of time that Lyle testified that they sat around waiting for the police 5 to 10 minutes before they even started to discuss the possibility that they would not get caught. Taking a couple minutes. Picking up the shells would take about a minute. What we're looking at there is 8 to 13 minutes just there, according to Lyle Menendez. What happened, though, is they wanted you to think that they were waiting around. They really didn't work like clockwork and do all these things. But once it was crunch time and they had to determine, well, can we really have done it during that period of time? Then they're going to start shaving time off. And in fact, they went from 8 at best, according to Lyle's testimony, to 13 minutes. They accounted for that in 4 minutes. That is to have the discussion, pick up all of the shells, make sure the shells that had their fingerprints on them. So we're talking about taking off 100 to 200%. So we then go next to what they did at the theater. Now, Lyle Menendez testified that they parked at the parking meters at the Century Theater, 14th Theater. Well, there are no parking meters there. And he said it took about 10 minutes. Well, let's see what the defense says they allotted the activity time. Well, that's 4 minutes. They allotted 4 minutes for that. And okay, to throw the guns out of the car was a couple minutes. Okay, that one's okay. Lyle Menendez testified it took a couple minutes. Of course, it taking a couple minutes going down 150 feet on the side of a road and going down there with 2 shotguns and then having to bury those guns and then having to come back up. 2 minutes is pretty quick, but they didn't say, well, that's not reasonable, let's lengthen that. They said, okay, we'll go 2 minutes on that one. So that one was okay. Now next, they went to a gas station and they threw away their bloody clothes, and according to Lyle Menendez, that took 5 minutes. They've accounted for that as 4 minutes. And getting lost at the Taste of LA, having to look around to find Perry Berman, and then having to find a phone, they allotted 2 minutes for that. So what do you know? Their totals work out to be 66 minutes, and they're allowed 67 minutes. So they could put in whatever times they want to, but it doesn't comport with the way Lyle Menendez testified, because if you plug in the times that Lyle Menendez testified to, then they would have been well beyond their allotted time after just going to buy the tickets and waiting around for the police to come and catch them. So that may give you an indication of Cindy Erdely and whether or not she has a reason to kind of color what she says, as opposed to Mrs. Valdry, who said that Grant Walker always came during that period of time after the initial time on Saturday. Next, I'm going to turn to some of the things that the defendant did in the week and weeks after the killings. According to defense witness, this is a defense witness, Roger Smith, during the week of the murders at a meeting at Live, Smith, who was then the chief financial officer, informed the defendants that they would not get the proceeds from the $5 million insurance policy on Jose Menendez that the company had purchased. It was because Jose had not taken the required physical. Now, the defendants want you to believe that they knew prior to killing their parents that they were aware of the fact that their father had not taken the physical. The defendants claim that their father had announced to them somehow, hey, I haven't taken my physical, so I don't have the $5 million policy yet. But Mr. Smith testified that after the murders, he was the one to inform the defendants of their not being entitled to the proceeds of the $5 million policy. And we know from the tape of December 11th, 1989, that Lyle Menendez had worked at the company for a period of time and was saying how he knew what kind of compensation his father was getting. In fact, knew more than the mother knew. What was the reaction of defendant Erik Menendez to this information being told by Roger Smith? Well, the defendant's reaction was, and the $15 million policy in favor of the company, was that in order? With regard to the post-murder spending, we know that from his statement on September 17th, 1989, Erik got an allowance of $180 a month. 4 days after the murders, defendant and Lyle bought Rolex watches and money clips. As Mark Heffernan testified, after the murders, Erik's spending was absolutely on a much larger scale. And we know further from the testimony that on November 29th, 1989, the defendant talks about buying a house in Beverly Hills for $8 million. We further know that Erik Menendez made an offer on a house in the Silver Strand area of Marina del Rey for $1.1 million in early 1990. We know that Erik Menendez bought a new Jeep, he bought a pool table, bought new furniture. And we know that on November 29th, 1989, Erik Menendez spoke of starting a corporation like the BBC, as in Billionaire Boys Club. We further know that there was some movement by Erik Menendez, according to Mark Slotkin, who was trying to advise the defendants about their investments. Erik was interested in some kind of a concert promotion. Now, as you know, the defendant is charged in count 1 and count 2 with murder, and in count 3 with conspiracy to commit murder of his parents. And it's charged in the information. There are, as I've indicated, 2 special circumstances, the multiple murder and lying in wait. And on behalf of the people of the state of California, I'm going to ask you to find the defendant guilty as charged in the indictment. Thank you.
Oh, it's the blue jury. I could have sworn I was just listening to a final argument to the gold jury for Lyle Menendez. And even before Mr. Kuriyama did what I knew he was going to do, which is try to blur the lines between what Erik did and what Erik said and what Lyle did and what Lyle said, I knew he was going to do that. And I was concerned that through the course of this trial, you've heard a lot of evidence that had to do with Lyle and his personality and things he said and things he did. And I wanted to make sure that you understood that you are not the blue jury, not only because you giggle and laugh back there all the time and we can hear you. You are the Erik Menendez jury. And in a strange way, in the way that people come together in courtrooms, in this artificial way, you belong to him and he belongs to you for now. Now, when you go back to your real lives, the more normal ones, where other people don't keep you waiting all the time, the notion that you are somehow affiliated with Erik Menendez will fade. But the decision that you make governing his life will never change. And it's a decision that all of you who actually deliberate and render a verdict in this case will live with for the rest of your lives. And from what little we know about all of you, from the jury selection process, I think all of you want to be very comfortable with that decision. I have left these here on purpose to talk about what you are and aren't supposed to do as jurors. And when we say supposed to do, some of these rules have to do with purely legal concepts, but others have to do with easier things to understand, such as the fact that jurors are human beings, and they have consciences like other human beings, and they have to live with their consciences. And we want to make sure that jurors make decisions that are based both on the law and on what is, in any sense of the word, moral. And the very, very first instruction, when the judge reads, which will be a rather large pile of instructions to you, says this: you must not be influenced by pity for a defendant or by prejudice against him. You must not be biased against the defendant because he has been arrested for this offense, charged with a crime, or brought to trial. None of these circumstances is evidence of guilt, and you must not infer or assume from any or all of them that he is more likely to be guilty than innocent. You must not be influenced by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. These photographs are here right now through Mr. Kuriyama's entire argument for no other reason but to upset you and inflame your passions, because they are ugly. Death by shotgun is ugly, no matter what the reason for it. And photographs like this, which we in the criminal law business have looked at, I personally, 23 years of doing murder cases, I've seen a lot of dead people. They are always horrible, and I think I know why, and maybe you would agree. God didn't mean for our bodies to be opened up in this fashion. And when they are, it looks terrible. There's a lot of blood. It's disfiguring. And it reminds all of us of our own mortality. So it's always a cheap prosecutorial trick to put up these dreadful photographs in the hopes that it will so inflame you against a defendant that you'll forget to ask the important question, which is, why did this happen? And not only why did it happen at all, but why did it happen when it happened? Because in any case charging crimes as serious as murder, and in the specific crimes that you're going to be instructed on here, there must be a joint operation, as the law says, between what a person does, the act, and why they do it, which is either their mental state or their intent. And strangely enough, when you first approach this theory of criminal law, this struck me as odd even in law school. What you do is not enough to render a judgment of what crime, if any, you've committed. You have to have the right, or in the actual term, the wrong attitude or mental state. And that's called in law school mens rea, okay? Which is the mental part of any crime. Mr. Kuriyama showed you briefly the definition of murder. To me falls the unpleasant for you task of having to educate you in the law of homicide in great detail, and I have a huge number of charts over there to do it with, but we're not going to do that right now. Maybe I won't even do it until tomorrow, because I am going to be talking to you for a long time. I am not going to ignore any of the evidence in this case. I'm not going to run away from it. We didn't do that during the course of the trial. Every piece of evidence that was testified to that was bad for us, we met head on, we cross-examined on it, we wanted you to weigh and consider whether every piece of evidence was believable. We did not do what the prosecution did, which was run away from the evidence that they could not deal with. And that was the evidence of extensive, disgusting, to use his word, perverted sexual abuse that took place inside this family for 12 years. Mr. Kuriyama did not ask one single question of Erik Menendez on the sexual abuse. And I will explain to you a little later in detail why that was true. All of Erik's life, as you heard from, we called 58 witnesses. They weren't all witnesses who had to do with his family background, but a great many of them were. But all of Erik's life, he was overshadowed by his brother Lyle. All of Erik's life, he was the lowest man on the totem pole of that family. Lyle, who I believe, and I believe you believe, loves Erik, gave perhaps the most poignant testimony about that when he said that even when he was small, he could see that the way Erik was treated in that family was so bad, he was so ridiculed, he was so belittled, he was so ignored in any meaningful way by his father, that to Lyle, the worst thing he could have been was Erik. But all of his life, Erik has been in the shadow of Lyle. And he put himself there many times. He would say, and he testified, I would stand behind Lyle, because Lyle could be the intermediary with the parents that Erik could not deal with at all. And that's fine. That gave Erik some protection. That gave Erik some ally during his growing up years. But in this trial, the decision that you make affects Erik, not Lyle. And if you decide Erik's guilt based on evidence or information that has to do with Lyle, I can assure you Lyle will not serve his prison term. Lyle would not go to the gas chamber for him. Whatever you do impacts Erik. And he has a right. He has this much of a right, after all the years in which he was second rate and second best and last to be considered, to have you give him the respect, criminally accused defendant that he is, to judge him for who he is. Because that's what this case really is about. These people are dead and they were killed by their own children. Now you have to ask, if you knew nothing else, what went on in that family for that to happen? Mr. Kuriyama wants to tell you about 2 or 3 little things that went on in the last year and nothing from before. But nobody is created between the age of 17 and 18. We're created from the time we're an infant, from the time we're a newborn. And so what we tried to do in our case is explain how could these people be killed by their own children? What was it they did? And more important, who did the children turn out to be? Mr. Kuriyama has already resorted to some name-calling. I suspect that in his next argument, because indeed he gets to argue to you again, there'll be a lot more name-calling. But so far he has called Erik a vicious, spoiled brat, something close to that. He should have gotten off his butt, I think he said, and gone to work. He has proposed a theory of premeditated murder that is based on a theory of why these crimes occurred that is completely obscure right now. Let's go back in time in this case. This started out, theoretically, as a killing for money. Well, Mr. Kuriyama didn't actually tell you they killed them for the money, perhaps because we so completely demolished that theory during the course of the defense case that he knows he can't make that argument with any conviction. But in spite of the fact he didn't tell you it was a killing for money, he nevertheless wants to talk about insurance policies that the defendant knew didn't exist, and he wants to talk about post-crime spending. So I will get to that. But the financial gain notion was pretty well destroyed when the witnesses came in and said that they knew there was no insurance policy because it was talked about at the office and it was talked about between Jose and Kitty Menendez, and Jose had all these reasons for not taking the physical. So that took care of that. And then Carlos Beralt testified. And Carlos Beralt gave the one piece of evidence that blew the financial theory out for all times. Jose Menendez told him that he had told his sons, not you're going to be disinherited if you don't shape up, which is how Mr. Kuriyama would have you hear it. What he told him was, you are out of the will. And Jose said he told that to Carlos. Jose said he told that to the boys before he was talking to Carlos Beralt, and he was talking to Carlos Beralt in June or July of 1989. So that pretty much put to rest the murder for money theory. So what was the next theory? The next theory, if I recall, was murder for hatred. And the problem with that is that not a single witness came into this courtroom, and I'm leaving Dr. Oziel completely aside for the moment, as a very special case. Not a single witness came into this courtroom who knew Erik Menendez and his parents, who said that Erik ever said a negative thing about either parent his entire life. And the same was true with respect to Big Brother. Not a single witness said that Lyle ever said a negative thing about his parents his entire life. Now, how many families do you know with 18 and 21-year-old children where the kids never complain, never say a negative thing about their parents? That is extremely unusual. But the fact is, there has been no evidence ever presented that Erik expressed any hatred towards his parents. And in my opinion, he had plenty of grounds for it. But based on what kind of person he had become, he didn't feel anger or hatred towards his parents. He idolized his father, and he felt sorry for his mother. So the hatred theory went nowhere. So now what is the theory of why these two young men killed their parents? Well, what I just heard was the Dr. Oziel theory. They killed their father because he was controlling them and dominating them, etc., etc. And so I understand at least where the prosecution's coming from now on the why Jose Menendez was killed, but I still haven't figured out what their theory is for why Mary Louise Menendez was killed. Surely, to quote my client, surely they don't believe that she was killed in the course of a mercy killing. Nobody could believe that. It is cuckoo. It is crazy. It is bizarre. It is the kind of thing that clearly you can wind up talking about if you spend too much time around L. Jerome Oziel. But short.
Overruled. You may proceed.
I don't understand that, but okay.
Go ahead. Just continue your argument.
This is the theory, the mercy killing theory that Dr. Oziel claims first came up on October 31st, that Erik testified was Dr. Oziel's idea, and that is again repeated on the December 11th tape. Now, during the course of this trial, the prosecution was faced with overwhelming evidence of constant, chronic, high-level and low-level cruelty by these parents towards their children. It went on and on. And now Mr. Kuriyama tells you that he wants you to ignore all of it. The same was true about the evidence of the sexual molestation. It was extensive, it was severe, it went on for years and years. It took many forms, and he wants you to ignore that too. He says it's made up. I say, prove it. He says, ignore everything that happened before. And I am telling you that it is a jury's obligation to weigh the evidence, not the bias of the prosecutor, but the evidence that was properly presented to you. This was not a case, as I'm sure you all noticed, where evidence just went on and witnesses just talked and the other side was silent and there were no judicial rulings. Every single piece of evidence that came in was fought over. And the court was called upon, more so than in many other trials, to make a lot of evidentiary decisions. And he made them. The judge made them either from the bench, or we all went over there and had our little powwows every few minutes, and sooner or later all these decisions were made and you heard the evidence come in, and it was properly before you, because if it wasn't, the judge wouldn't have let you hear it. It's that simple. That's what his job is, to decide. And in deciding what evidence is properly before you is the overriding theory of what is relevant, what matters, what speaks to the issues in the case. And the defense in this case has always asserted that this horrible, ugly thing happened because those children lived in a horrible, ugly environment for years, in which they were terrified, in which Erik became an extraordinarily fearful and anxious child, so that when he reached an age and a place in his life where he could not take the worst of it anymore, and made some feeble effort to stop it by going to his, frankly, equally screwed up brother for help, this is what ultimately ensued. And what we wanted to do in presenting our evidence was make you understand why it was Erik reacted with such fear, why it was he believed that his parents were about to kill him, and why it was this happened the way it did. And so, how do you prove that? I mean, obviously, if I had a videotape of Jose Menendez performing a sex act on Erik, I would have put that on, and I wouldn't have needed all those other witnesses. But the crimes that were committed against Erik Menendez did not wind up in this case, and don't ever wind up with the police coming in and taking pictures. It's very easy to go to a crime scene of a homicide and to take all the gruesome pictures in the world and parade them later in front of a jury and get those people upset. But where is the picture of Jose Menendez bending Erik over the footboard of his bed when he's 12 years old so that his father can now go all the way in spite of the child's screams? Well, there is such a picture. But unfortunately, it only lives in Erik's mind now. And I doubt very much that Jose Menendez was very troubled by it during his lifetime. But I can't give you that picture. I can give you something very unusual to find in cases like this, which is some hard evidence of molestation. And hard evidence of molestation is very hard to come by because molesters are secret. They are sneaky. After all, they are exploiting weak little children. And they hide it because they know the rest of us don't think much of that. I'm going to leave these up here. And I'm going to leave them up here because ultimately you'll get over the trick that's being played on you and the shock value will diminish. So that when you go back into the jury room to decide this case, you're not going to decide it because you're still upset over those photographs. And I'm not going to leave my photographs up here because I'm not trying to shock you. Now, this is a copy of the photograph that's in the exhibit, but this is only a copy of it. And I'll show you why I'm putting a copy up. Now, this is the crime of Erik Menendez. And I cannot show you the crime that Jose Menendez committed on him, but you heard about some of the things that he liked to do to his little boy. And one of them was to stick tacks like this in his thighs and in his butt, and to run needles across his penis. Now, that's this man. And I don't recall if there are autopsy photographs of this man where you can see his penis, the one that he stuck in this body, that Mr. Kuriyama tells you is all made up. The proof that it isn't all made up is who Erik wound up being. And I put Dr. Vickery on the stand to tell you how sick this kid got behind the home life that these two very dead people provided him with. Now there's one thing that Mr. Kuriyama, I want you to look very carefully at this proof sheet. This is a proof sheet of the sequence of the photographs from Erik's 6th birthday party. These photographs were found in this envelope. This envelope has the handwriting of his mother, Mary Louise Menendez, and she had a beautiful handwriting. She was a school teacher. And she wrote Erik's birthday, November 1976. And inside this envelope were the original small prints taken on that roll, from which this is an enlargement. And also inside that envelope were the original negatives. And so what we did was we had blow-ups made from the original negatives. And we had a proof sheet made of the order of the photographs on the roll, so we could see which was taken first, which was taken second. Now I happen to know, for reasons I cannot reveal to you, what the prosecution's theory is about this photograph and the one of Lyle, which I will also show you. This is the one of Lyle's nakedness, which was saved by his mother, kept in that envelope. Now, both from the cross-examination of Erik, I suppose, was the first clue that the prosecution's theory is that the boys, the children, took the naked pictures. And somehow that theory, I think, has to do with some kind of visual perspective that they want you to speculate about based on the height of the person who took the picture. Now, that's wonderful, except people who take pictures can bend down and take pictures of little children's genitals, even if they're big people, even if they're grown-ups. But frankly, there is absolute hard proof that Erik Menendez did not take this nasty picture of his brother. And here's the proof. If I haven't misplaced it, okay? Here it is. The proof sheet is the proof. The sequence of the photographs. Here is a gathering of people. Here is Lyle in the bathtub, one can assume the morning of the birthday party. And here is Erik in bed. Now, Erik is in bed when this naked picture of Lyle is being taken. See, here's the next picture on the roll. Now, are we supposed to believe that 6-year-old Erik, who testified he was not allowed to handle a camera until he was 12 or 13, got out of bed to go take a naked picture of his brother, and then got back into bed so someone could take a picture waking him up? And it isn't until way down here on the roll that the naked picture of Erik shows up, and then a picture of Mrs. Menendez's favorite thing, her animal, Tristesse. And I think it's really amazing if you could go back and remember the testimony, for example, of Terry Baralt, who was Jose's sister. She was asked about Mary Louise Menendez and who was it or what was it that Mary Louise Menendez showed affection for. And when she started talking about the animals, you could see the animation even in Mrs. Baralt's face. Oh, Kitty loved her animals. She showed them all sorts of affection. She took such good care of them. She never showed anything like that to her children. But here's a picture of her favorite little dog, Tristesse, next to her naked child. I promised I wouldn't leave him up, and I won't. I'm going to talk later about all of the evidence that corroborates the sexual molestation of these boys in this case. I keep promising what I'm going to do later. But you can't do everything at once. I will say this about the molestation evidence right now, and that is this. We presented this evidence through the testimony of Erik Menendez, and Mr. Kuriyama refused to ask him a single question about it. He ran from this evidence because he knew if he questioned Erik, if he used the tool that you're supposed to use to question a witness, which is cross-examination, which he does rather well. I mean, he cross-examined Erik about the crime scene ad nauseum. He questioned him about what they did after for a day and a half. He knows how to ask questions, and he is a very aggressive cross-examiner. He argues a lot. He insinuates. He's quite sarcastic and snide. He's got all the tools of the trade, and he used them. And he just spoke to you about how successful he was using those tools. Now, I will dispute some of the things he said about how successful he was, but it is true. The purpose of cross-examination is to try to show when a witness is not telling the truth or is mistaken in their testimony. And Mr. Kuriyama does it rather well. But he didn't ask a single question about the molestation. Why? Because he was afraid that he would not be able to show that it wasn't true. And he didn't want you to hear it. He wanted you to hear about the shooting. He wants you to see bloody photographs over and over. But he didn't want you to hear Erik Menendez talking about these hideous things again. He hoped perhaps you'd forget about it somehow, that it would leave your consciousness if he didn't cross-examine about it. They put Dr. Oziel on the witness stand, who said dreadful things, horrible things, things that if you believe they're true, yes, they're guilty of first-degree murder. That's what Dr. Oziel was. He was the entire centerpiece of their case. He is the only witness who could give you first-degree murder. It rises or falls with him. There's nothing else. And they put him up here, and he said these dreadful things, and we cross-examined him on everything he said they said. We cross-examined him on everything he said he did, all his reasons, all his motives, what happened in the session, how were they conducted. We didn't run from that evidence. And we were also able, not just by cross-examining him and showing what sort of witness he was, we were able to show what sort of person he was, both through the way he testified, the things he said, and the other people that we put on to talk about him. And that's what you do. If this is really a search for truth, you cross-examine witnesses and you test what they're saying to see if it's true. And they ask nothing about the molestation, and therefore it is totally uncontradicted evidence. Nobody came in here and said Jose Menendez didn't or couldn't have molested his kids. Nobody came in here and said Erik told me the molestation was a fantasy. It's completely uncontroverted. Now, it wasn't put on for you to say, oh, these people are monsters. They did dreadful things. They deserve to die. We never called Jose or Mary Louise Menendez monsters. Their children never said a negative word about them in life, and they didn't say a negative word about them in death. They didn't say they were terrible people, they were bad people. All they did was tell you what it was like living with them. What were the things that were done to them? How did they accommodate themselves to it? And how did they feel about themselves and about life as a result of having been raised by them? They didn't get up here and call their parents names, and neither did anybody else that we called. They described these people. They talked about their personalities. They talked about their character. They talked about how they raised their kids, but they didn't call them names. They didn't call them vicious beasts or monsters. And they weren't monsters. They were people. They were people who did some dreadful things to their children, but they were people. And Erik is a person, not a vicious brat, not a cold-blooded killer. He's a person. And in order for you to decide why he did what he did, you have to decide what kind of person is he. And after lunch, I have some charts I'm going to show you to help remind you of who it is he was before Mr. Kuriyama got his hands on him to characterize him in his totally fantastic way. Now, the other way to challenge evidence, such as the molestation evidence in this case, is to call your own expert witnesses to say, that is a made-up story. It doesn't fit the research. It doesn't fit the way other kids talk about it. I don't believe him. He didn't have the right demeanor when we spoke. He didn't give the right kind of details. There's a lot of research, as you learned, going on in the field of child sexual abuse and other forms of child abuse. There are people conducting studies all over the country. We called expert witnesses. First of all, frankly, to tell you that he was telling the truth, that in their opinion, and they were qualified, internationally respected experts, that in their opinion he was molested. That's why we called them, to overcome what we knew would be the prosecution saying, it didn't happen. Why didn't it happen? Because Mr. Kuriyama doesn't want you to think it happened. He doesn't want you to believe it. And a lot of people have a hard time believing that these things happen. That's been the tragedy in this country with child abuse for so long. You don't want to believe people do this to their kids. You wouldn't do this to your kids. And you wouldn't want anybody you know to do this to your kids. And you don't want to believe it happens. And there's a lot of resistance to it. And there's a lot of resistance because we don't respect children very much in this country. In spite of all the lip service that we give to child issues, we think children lie. We think children make things up. We think children fantasize. So when children are victims, we scrutinize them differently than we do adults. So they have a hard time, these children, convincing the grown-up world that bad things are happening to them. And so we brought in these experts to validate, flat out, what he was saying. Now, you don't have to believe him just because the experts do. Clearly you don't. You are the judges of the facts. You have to decide, did it happen, on your own. And not because Dr. Burgess, who works with the FBI, even though she's got terrific law enforcement credentials, has worked with law enforcement for years and years, cannot be called a defense-biased witness. Even if she believes him, you don't have to believe him. Even if Dr. Vickery comes in here and tells you what kind of person Erik really is, you don't have to believe him either, because you get to decide the facts. But we brought you these people so you'd have some help in making that decision. And beyond that, we brought in the experts on abuse so that you would understand why it is that abused kids see the world differently than you or I. And therefore, why it is that abused kids could honestly believe that their parents were going to kill them and take this action motivated by fear, when in fact, as they found out, and we all know, their parents at that moment at least were not about to kill them. They were wrong. But the issue is, could they have honestly believed that based on what happened that week, viewed through the prism of their entire previous life? Because if you or I or any of us, the non-abused children, hopefully, I don't know that much about your backgrounds, the non-abused children, at least not this kind of abuse, in this courtroom, walked in to that house on Elm Drive at approximately 10 o'clock on August 20th and had had the same interchange with Jose and Mary Louise Menendez that Erik and Lyle did, none of us would have thought, oh my God, they're about to kill me. We just wouldn't have, because we wouldn't have had the knowledge of the special knowledge, as it's called, of the prior threats of their hostile and aggressive behavior to us. We wouldn't be in fear of them. We're big people, and they're not our parents, so they don't have that kind of power over us. We wouldn't understand the significance of the gestures or the significance of the words. It would mean nothing to us. And so as reasonable and reasonably normal, I hope, people in that foyer that night, none of this would have had meaning to us. But the issue for you is, did it have meaning for Erik and Lyle Menendez? And based on their history and based on what happens to severely abused kids and how they respond to threats and fear, could it be said that they had an honest and actual belief that their parents were about to kill them? And the reason that is the question is because that is the defense in this case. And Your Honor, this is a good time to stop that.
We'll be in recess until 1:30. Don't discuss the matter with anyone. Don't form any final opinions about the case, and we'll resume promptly at 1:30.
Which talked about not being influenced by sentiment or sympathy. And I want to make something very clear here. We did not put on all the evidence of all the things that were done to Erik in order to evoke sympathy. If that's all we wanted to do with that evidence, if that's all we thought it was relevant for, we would wait and see if there were a penalty trial in this case when such evidence is often presented and present it then. The purpose of that evidence was to show you what state of mind he was in on the night of August 20th and how all of his life experiences led up to the condition that he was in that night. And so that was the actual purpose for it, but we have an affirmative reason why we do not want you to decide this case based on sympathy for him or prejudice against him. And it really has to do with a philosophical issue, and that issue is that abused children in this country do not want pity for what they have been through. And Erik doesn't want pity for what he has been through. Pity isn't really what's going to solve this problem. What he wants is understanding. And the reason we put that evidence on is in the hopes that you will understand what happens to a child, how they do not develop normally, what happens to their view of themselves and their view of the world, and how they can then be set on this collision course with violence that the Menendez brothers were set on. We want your understanding, and we want you to apply the law. Now, the law that I'm going to talk to you about, and I have to do it now because the rest of my argument won't make sense. I'm not going to do it all at once because it's really tedious, but I'm going to do some of it. The law is a little behind psychology, if you will, and that's sort of typical in our society. It takes a while before new knowledge is totally absorbed into the law. When we started this case, if you remember the opening statement that I gave, I talked to you about self-defense. Now, what I didn't tell you then and what we didn't tell you in the juror questionnaires, because there's no purpose in making things too complicated, is that in the state of California there are two different kinds of self-defense. One of them is what is called complete or perfect self-defense. And perfect self-defense is something that you had some questions about, that we asked you about on the juror questionnaire. And it has to do with a person who has a good faith and a reasonable belief that they need to use deadly force to defend themselves against imminent peril to their life, or the imminent threat of great bodily injury, or the imminent threat of the commission of what we call in the law, in our very ungrammatical English, a forcible and atrocious crime. And if someone acts in perfect self-defense, and if a jury finds that they acted with a good faith and a reasonable belief in the contingency of peril, that person is not guilty of any crime at all. That is justifiable homicide. Now, when we started this case, we did not know all of how the evidence would come out, and we did not know what the legal rulings in this case would be. And as a consequence, you are not going to be instructed on perfect self-defense, which could lead to a finding of justifiable homicide. And that is a matter of some disappointment to me, but my disappointment isn't all that relevant. You are nevertheless going to be given a verdict form that allows you to vote not guilty. And that is a constitutional issue. No jury can ever be told they must convict. Every jury has the option of acquitting. However, I do not have the option of arguing the theory of perfect self-defense to you in order to bring about that acquittal, because you're not being given that instruction. You are, however, going to be given the instruction on what's known as imperfect self-defense. And the difference in imperfect self-defense is that is when a person has an honest and good faith belief that is not reasonable, that is unreasonable, in the need to defend themselves against imminent peril to life, or imminent threat of great bodily injury, or imminent threat of the commission of a forcible and atrocious crime. And what that means is if someone is truly in fear, actual fear, that they're about to be killed, or they're about to suffer great bodily injury, or they're about to, for example, in our case, be raped, that person, if they act to defend themselves, can be convicted of no more than manslaughter. And I have, in order to tell you about that instruction and that rule, I want to start with the instruction that Mr. Kuriyama already showed you about murder. My client is charged in 2 counts with murder, and the people are asking you to make a finding that it is first-degree murder. And later on, if I feel like it, frankly, later on, if it seems to fit in the argument, I'll go back and describe the difference to you of what second-degree murder is versus first-degree murder. But I can tell you now very plainly, I am going to be arguing in this case that if you must convict, that you convict for no more than manslaughter. And later on, I will get into the death. There's 2 kinds of murder that you'll be instructed on, first degree and second degree. There's 2 kinds of manslaughter you'll be instructed on, voluntary and involuntary. And I will go through in more detail a little later all of the distinctions between those 4. But in order for you to understand the rest of my argument having to do with why Erik felt fear, you need to know where that goes ultimately in your decision-making process. So, the definition of murder has 3 elements to be proven. That a human being was killed, there's no dispute about that. That the killing was unlawful, and for reasons I'll show you in a minute, there's really no dispute about that, given the instructions you're going to be given. And that the killing was done with malice aforethought. Now that's the key here as to whether a killing on, I told you about justifiable homicide, that's a lawful killing. If you act in perfect self-defense, it's a lawful killing. If you act in imperfect self-defense, it is an unlawful killing, but it is not murder. So you can have an unlawful killing that is a manslaughter that is not murder. And the difference between murder and manslaughter is this very peculiar concept called malice aforethought. As Mr. Kuriyama read to you, malice doesn't mean in the law what we feel it means in ordinary language. It doesn't mean hatred. It doesn't mean any particular negative emotion. If I have to put it in layman's language, the only way that I can understand it is a negative way. Malice means, pardon my French, without a damn good reason. If you have a damn good reason, a reason that the law accepts for doing your unlawful killing, then malice is not present. And in fact, it's really a recognition, if you will, in the law. The criminal law is really a sort of law that combines morality and psychology. And the morality part is a judgment. And the judgment is if you are acting out of fear and you're acting in good faith and you believe you're defending yourself, you're just not as culpable and you shouldn't be held to as severe a crime as if you're acting just for the fun of it, for no damn good reason, which is what malice is. By the same token, to complicate your life more, there's another way in which you can analyze situations in which people commit unlawful killings that are not murder. Another way beside imperfect self-defense, and that is called provocation, heat of passion. And that is commonly what happens, for example, if 2 people in a bar are in whatever condition. Let's assume they're sober because that eliminates other complexities. And one of the people in the bar calls the other a racial epithet, for example. Now, those are known as fighting words in the law. And if you insult someone that way, and as a normal person, they take offense and get very excited and worked up, and if they take action against you, that can be considered sufficient provocation so that when they take action against you, it isn't murder. And there are definitions you'll get of what emotions constitute sufficient provocation. Strangely enough, one of those emotions is fear. So there's actually 2 paths to wind up with manslaughter in this case. The imperfect self-defense, and under the notion of sudden provocation, heat of passion, is this concept. Let us assume for a moment that in this particular case, Erik had not gone to Lyle and talked about his molestation. Lyle had not gone to Jose Menendez and had that talk that led to the death threats. And the fear of death was not the rising level of fear over the next few days. Let's assume a different scenario. Let's assume that Jose Menendez told Erik outright, I'm going to continue having sex with you because you are my toy and my plaything. You are my throwaway son. I really don't care how you feel. And it's going to go on. Words. And at that point, Erik killed his father. Now that is a classic situation of sufficient provocation, heat of passion. Okay? without this other component of self-defense. And in this case, I will argue to you later, there is another way of analyzing what happened in this family as a provocation, heat of passion episode rather than as a fear of death, self-defense episode. It really doesn't matter which one you decide makes more sense to you. And it really doesn't matter if all of you decide on the same theory of manslaughter. Some of you could actually believe that this fits sudden provocation, heat of passion, and the others could decide it fits imperfect self-defense, and you'd get to the same result, and that would be perfectly legitimate. But for now, if I know where Miss Morrissey put the charts. There, here. Okay. Now, I'm not sure which, I think I'm going to put them here because this is more stable on the tripod. Problem is I can't read them. And as I just told you, this is an instruction you're going to get. Sorry they're not printed darker. I didn't do it. Okay, and what this instruction tells you is that the distinction between murder and manslaughter is that murder requires malice, while manslaughter does not. When the act causing death, though unlawful, is done in the heat of passion or is excited by a sudden quarrel, such as amounts to adequate provocation, or, and here's where we get to the imperfect self-defense part, in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, the offense is manslaughter. In such a case, even if an intentional intent to kill exists, the law is that malice, which is an essential element of murder, is absent. In a way, the easiest way to, if you want to get real analytical about this, the easiest way to look at it is that these two emotional states, heat of passion or good faith but unreasonable belief, just erases malice, just counteracts it. And that's the simplest way, I think, of analyzing the instructions, because if you try to figure out what is malice and is it there, you're going to go crazy because the instructions don't really tell you what malice is. For example, the instruction with respect to express malice basically tells you express malice is intent to kill. And that can be confusing because voluntary manslaughter, a crime where there is no malice, also has intent to kill. The difference is, though, that if it's intent to kill in a voluntary manslaughter setting, if it has one of these two emotional states, the malice of murder has been erased, and that's about the only way to make sense of this. Now, to establish that a killing is murder and not manslaughter, the burden is on the people to prove beyond a reasonable doubt each of the elements of murder and that the act which caused the death was not done in this heat of passion or the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. And I want to focus on that for one moment here because I think this is something you've all heard about, the burden of proof beyond a reasonable doubt. We put it in the juror questionnaires. None of you believe the innocent should have to prove themselves innocent or a defendant should have to prove himself innocent. If you thought that, you wouldn't be here. And all of you seem to understand that concept of reasonable doubt. But what juries don't always understand is that if you really think about what that means, what it means is basically the prosecution has to prove us wrong beyond a reasonable doubt, because we clearly have presented evidence to show that Erik's state of mind on the night of the shooting fit one or both of these categories. And therefore, for them to win and for you to come in with a murder conviction rather than a manslaughter, they have to prove that we are wrong beyond a reasonable doubt, because they have to prove that murder is true and manslaughter is not true beyond a reasonable doubt. They have to prove every element of murder beyond a reasonable doubt. And if we have raised through our evidence a reasonable doubt that malice was present, a reasonable doubt as to whether or not they were acting in heat of passion or whether or not they were acting in fear, they lose, we win. And it can be no more than manslaughter. And you will see throughout the instructions that the burden is always on the people to prove beyond a reasonable doubt the crime that they are asking you for. And if they can't do that, you are compelled by law to find the lesser crime. I was just talking about reasonable doubt. I'll put it up. Again, it's the way these legal concepts are framed is so alien to ordinary speech. It's very hard for people to really understand the meanings. And I'll tell you, I'll read this to you, and then I'll tell you what I really think how reasonable doubt operates for jurors versus the definition. Here's the definition. A defendant in a criminal action is presumed to be innocent until the contrary is proved, and in case of a reasonable doubt whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. This presumption places upon the people the burden of proving his guilt beyond a reasonable doubt. Now, as I just told you, and you'll see it in some of the other instructions, that in case of a reasonable doubt whether his guilt of a particular crime is shown, he is entitled to a verdict of not guilty for that crime. For example, you're going to get the verdict forms here. There's only one not guilty verdict form. We didn't do separate ones for each crime. So let's say you get together and in your deliberations you decide, no, there is no evidence, there is not evidence beyond a reasonable doubt that he's guilty of first-degree murder. You won't have a first-degree murder not guilty form to sign at that point, but in your head you will have made that decision. He's not guilty of first-degree murder, let's look at second-degree murder. And again, if you look at second-degree murder and you say, no, I still don't see malice because of this defense evidence, you won't have a verdict form at that point that says not guilty of second-degree murder. That's just a decision that you have made and discussed, and I assume votes that you've taken. So then you get down to the next level, which is voluntary manslaughter. And you look at the definition of that and you weigh the evidence and you may say, no, I don't think they have proven beyond a reasonable doubt that he intended to kill, and therefore he's not guilty of voluntary manslaughter. And you won't have a verdict form that says not guilty for that either. That's the decision, that's your agreement. And then you get down to involuntary manslaughter and you decide, yes, have they proven involuntary manslaughter beyond a reasonable doubt? And if you don't believe that, then you get to sign the not guilty verdict form. But at every level, the people have to prove all the necessary elements beyond a reasonable doubt. And to do that, you have to decide what the facts are. Did they prove the facts beyond a reasonable doubt that are necessary to come in with the conviction that they want? Or did the defense prove facts that make me doubt that they have done that they have proven murder, or that they have proven intent to kill? Now, this is the part of this instruction that always makes me sort of smile, because it's pretending to define for you what reasonable doubt is, but I don't know that anybody ever really gets it. Reasonable doubt is, and that has nothing to do with intelligence, it has to do with we don't think this way most of the time. Reasonable doubt is defined as follows. It is not a mere possible doubt, because everything relating to human affairs and depending on moral evidence is open to some possible or imaginary doubt. Now, you know, you can hypothesize what that means. Pigs can fly, for example. I guess that's possible. I've never seen it, but I can imagine it. But it really does mean something like that. You know, anything is possible. Spaceships could land on the courthouse. It is that state of the case which after, and I had a client once who really thought spaceships were landing on the courthouse. So it is that state of the case which after the entire comparison and consideration of all the evidence leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charge. Makes perfect sense, right? Okay, I guess what it means, though, it's an issue of conscience. I think what it means, and I think how jurors decided, is this. Look, this is serious business being a juror in a criminal case. What I decide has enormous consequences for any case. I mean, being a convicted criminal for a citizen is a big thing, no matter what the crime. Certainly, this is the most serious of all kinds of cases. But the standard's the same, whether we're talking about drunk driving or murder, strangely enough, because the notion is anytime someone's convicted of a crime, the state then has power over them for punishment purposes. And so, every single time, jurors have to feel confident that their verdict is correct. And this is a way of trying to tell you what your internal process should be that makes you feel confident, an abiding conviction, something you really believe in and can hold on to even a week after the case is over, and 2 weeks later, and a year from now, and 10 years from now. And to a moral certainty, I don't really know what that means except that you are morally comfortable with your decision, that you're never going to second guess yourself and worry and wonder. And another way that people have talked about this is having the same confidence in your decision as you would have in the most important decisions in your life. Now, I'm not sure what those are. We used to talk about it being in terms of the person you marry, but you know, this is California, and given the divorce rates, who has confidence in that decision anymore?
All right, ladies and gentlemen, I am going to instruct you on the law at the end of the trial. Counsel at this point during their argument are just referring to certain legal principles. I'll give you all the legal definitions at the end of the trial. And another reminder, when counsel comment on the evidence, whichever lawyer it is, again, they are just commenting on the evidence. You are the ones who evaluate the evidence and decide the evidence in this case, and they're just commenting on it at this point. All right, you may proceed.
Thank you, Your Honor. In any event, the notion is it's an important decision and you have to decide it with that level of commitment and seriousness. Now, this is the definition I was telling you before, which you will receive this instruction. This is imperfect, so-called imperfect self-defense. A person who kills another person in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, or the commission of a forcible and atrocious crime, kills unlawfully but does not harbor malice aforethought and is not guilty of murder. This would be so even though a reasonable person, that's like one of us, in the same situation, seeing and knowing the same facts, would not have had the same belief that it was necessary to defend. Such an honest but unreasonable belief is not a defense to the crime of voluntary or involuntary manslaughter. And what that means is, as I told you before, it is unlawful to kill in an honest but unreasonable belief, but it isn't murder. And so it's not a defense to the non-murder unlawful killing, which is manslaughter. Forcible sodomy is a forcible and atrocious crime, so that if you kill to prevent someone from doing that to you, you fit within this definition. Now, I just want to point one thing out to you, and this is that the unreasonableness of the belief can apply to all of the considerations here. In other words, you can be unreasonable in your belief that it's necessary for you to defend at that moment rather than do something else, say, like flee. You can be unreasonable in your belief that the peril that you're concerned about is actually life-threatening rather than some lesser form of harm to you. And you can be unreasonable in your belief that the peril is imminent, that it's going to happen instantaneously rather than a little bit later. So in all those ways it can be unreasonable, but if you are honest, if you have this true conviction, this true belief, then you can't be convicted of more than manslaughter. And finally, my favorite instruction here is involuntary manslaughter. And here's how it fits in, this concept of involuntary manslaughter, into the other instructions in this case. Every person who unlawfully kills a human being without malice aforethought and without an intent to kill is guilty of the crime of involuntary manslaughter in violation of Penal Code Section 192B. That's the section that defines manslaughter. In order to prove such crime, each of the following elements must be proved. Number one, a human being was killed, and number two, the killing was unlawful. And so you can see it's the first two elements, but missing the critical third element for murder. A killing is unlawful within the meaning of this instruction if it occurred in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. So this is defining the imperfect self-defense form of unlawful killing that is nevertheless manslaughter. And the only difference between voluntary and involuntary with respect to definition is, one, they have to prove beyond a reasonable doubt an intent to kill. That's for voluntary. And if they fail to prove an intent to kill beyond a reasonable doubt, then it is involuntary manslaughter. Now, the other method of getting to manslaughter, the sufficient provocation, heat of passion also leads to both voluntary and involuntary, and there are other instructions that tell you that. There. That wasn't so bad. Now we can move on. And we move on to one that I could show you the part of the instruction, but I think I'll just read it. I also have a copy of all the instructions you're going to get here. And this one has to do with a concept you've all heard about, but probably have not ever gotten a legal instruction on before. And it's called circumstantial evidence. Circumstantial evidence basically, and I'm not going to try to define it specifically because it's a long, complicated instruction, and you are to be guided by the instruction. But let me give you some simple differences. If I see one of you, for example, take the pencil of another juror, and I testify I saw juror X take juror Y's pencil, that is direct evidence that juror X took the pencil. It's direct because it was witnessed directly, okay? By the same token, if juror X says, I took juror Y's pencil, his statement to that effect is also direct evidence that juror X took juror Y's pencil. But if instead of that, we have two jurors alone in the jury room, and juror Y puts her pencil down on the table and leaves, and juror X is left there alone, and 10 minutes later juror Y comes back and the pencil is missing, that is circumstantial evidence that juror X took the pencil, because it was not directly observed and it was not admitted, okay? So circumstantial evidence is evidence, as we define it, that leads to an inference, and that inference leads to establishing the ultimate fact. The ultimate fact in my hypothetical is X took the pencil. The inference in the second example I gave you is, since there's no one else in the room and Y left the pencil and the pencil's missing, X must have taken it. That kind of thinking requires an inference. Now, many, many items of evidence that are presented in a case can raise different inferences. The same piece of evidence, and you've already heard some differences of opinion both throughout the trial, and you're about to hear a whole bunch of them. Differences of opinion in what things mean. Here's the fact. What does it mean? Because some facts are being used to prove an ultimate issue. For example, there's lots of things here that the prosecution at various times, either through Dr. Oziel or in cross-examining experts, claim is evidence that there was a pre-existing plan to kill. That's been a big component of their case from the very beginning. But the evidence they're talking about is circumstantial evidence. And I'm going to analyze some of it. But just to focus on the simplest example is the fact that guns were bought in advance. That's a big piece of circumstantial evidence in the prosecution's theory that there is a plan. But it is circumstantial evidence. And because of that, it's subject to inferences. It doesn't directly prove there's a plan. I mean, it's only the purchase of guns. It's not the writing out of a plan. So you have to make certain logical inferences from it. And the rule of law is, if an item of evidence, a fact like that, is subject to two or more reasonable interpretations, and one of those reasonable interpretations points to innocence, in other words, points to proving a fact that helps the defendant, and the other reasonable inference points to guilt, or points to help to proving a fact that helps the prosecution, because the burden of proof is on the prosecution, because reasonable doubt is the standard, you must find that interpretation which points to innocence. That's the circumstantial evidence rule. And now I'm going to read it to you so that you see how it works in the law. However, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances, that's the facts, are not only consistent with the theory that the defendant is guilty of the crime, but cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. It's not simple, but it's easier if you read it, in fact. And I think you're going to have a set of instructions in the jury room, so you'll be able to read them. Also, if the circumstantial evidence is susceptible of two reasonable interpretations, one of which points to the defendant's guilt and the other to his innocence, you must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. Now, there is a savings clause here, though. If, on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation is unreasonable, you must accept the reasonable interpretation and reject the unreasonable. Now, when they're talking in this instruction about reasonable and unreasonable interpretations, they're talking about your analysis of the evidence, not what the defendant's interpretation of things was. Okay, so I don't want you to confuse this notion, how you evaluate circumstantial evidence, with the other notion of a good faith but unreasonable belief, because it has nothing to do with that. Okay. That's all we're going to do about instructions for the moment. Now, I want to return for a moment to my analysis, if you will, or my puzzlement, if you will, about what the prosecution's theory of the case is at the moment. As I said to you, it originally started out as some notion of a killing for money. Now, you understand, because you've been here and you've heard all the evidence that they have on this point, that what's always been peculiar, as I think I told you in the opening statement, about their notion of killing for money, is that they never had one shred of evidence that before the crimes, Erik ever expressed any need for money, any interest in getting money, any desire to kill his parents for money, any complaints about his financial situation. And that is very typical evidence in a case where they're asserting that it's a killing for money. And I can think of a situation, perhaps, an extreme case, where a kid could kill a parent for money. And here's what it would be, and it does happen. There are some people, children, who get very strung out on drugs and who get very involved with very bad crowds, okay? And I can see situations where someone who has been involved with drugs, involved with gangs, involved in criminal activity, who could get to that point where they could consider killing a parent for money. But there's anything like that going on here. So for them to simply assert that the killing was based on money has to do with a certain kind of prejudice, a certain kind of discrimination, if you will, that has been going on in this case from the very beginning. And it's something Americans sort of like to do, but it's called hate the rich. And this notion of discrimination has filtered through the whole case, even in the attitudes that both prosecutors showed towards both defendants when they were on the witness stand. It's one thing to be hostile to a witness who you know you can show is an incompetent and unethical and lying person. It's another thing just to be nasty because you're either the defendant or you're a defense expert, or because the prosecutor wants to convey the image that you're a snotty rich kid, even if you never act like a snotty rich kid. So this notion here that somehow because the family had money, that is a negative quality of Erik and of his brother, has managed to go through this trial when if they were making the same kind of discriminatory, if they were displaying the same discriminatory attitude towards these defendants because they were, say, Chicano, or black, or Jewish, or Muslim, or any other category of person, it would be unthinkable. It would be outrageous, and everyone would be offended. But they've been allowed to raise this inference over and over again that there's something basically bad about the boys because their parents had money. And the sad thing about that is that the fact that their parents had money made their lives worse because it gave the parents more control and more isolation, more insulation, if you will, from the probing eye of other people who might care. It also made them look successful. And we have this weird dichotomy in our culture, I believe. On the one hand, we hate the rich, and on the other hand, we all want to be them.
So we both admire them for their money and are sort of in awe of them, and on the other hand, resent them. And the resentment here is falling on the heads of the two brothers. Now, you have to ask yourself, is there any reason why, given the nature of family relationships, how children are connected to parents, how dependent they are, how they're born wanting to love their parents, how parents can limit their universe and limit their vision and keep them very focused on the family? Is there any reason to believe that the children of the rich love their parents or are linked to their parents or are bonded to their parents to any less degree than the children of the poor? And so you say to yourself, I hope, what would the prosecution be saying in this case, with no evidence whatsoever of a pre-existing need or desire for money? What would they be saying in this case if the Menendezes were poor? They killed them for something else. And of course, they have slid to the something else theory too, because they were unable to prove that the killing here was for money. Not only because there was no pre-existing evidence of it, but because we were able to show that Erik and Lyle knew they were disinherited. Their father had told them. We were able to show they knew that if they had just waited a few weeks, there would have been that $5 million policy. And if money was their issue, they would have waited. If any plan was their issue, they would have waited 2 weeks to get handguns. And we'll get back to that in a minute. But all of this notion of money links up with this notion of plan, and plan is what they need to get you to convict of first-degree murder. Without a plan, there is no murder in this case. Okay. One point I wanted to make about their supposed money evidence. Mr. Kuriyama misstated the import of Roger Smith's testimony. Roger Smith testified that when he says at the meeting on Tuesday at Live Entertainment that there is no $5 million policy, that nobody is surprised. That the impression he gets is that clearly the family, which was Erik and Lyle and Uncle Carlos and I think Uncle Brian, knew that there was no $5 million policy because they didn't react. They showed no surprise. And Carlos testified, Carlos Baralt, that he knew before that meeting that Jose had talked about the fact that he hadn't taken the physical, and that at the very least Maria Menendez, Jose's mother, and Lyle knew that he hadn't taken the physical and therefore didn't have the policy before he died. So the importance of Roger Smith in that aspect of his testimony was to corroborate both Erik and Lyle, so that it isn't just their word telling you that they knew there was no such policy. And Mr. Smith told you that he had had conversations with Jose Menendez around the office, that Jose was being pressed by Rod Tovinger, who I believe was the controller of the business, to take the physical and so that he could get this provision in his contract, and he kept putting it off and stalling. And we have wondered for 3.5 years, as trying to read the minds of Jose and Mary Louise Menendez, why it was that Jose did not take that physical. And there were two possible explanations, I think, based on the evidence. One is that he had had this heart attack or some kind of angina problem. It wasn't a full-blown heart attack in January of 1989. That's why he didn't take that trip to Amsterdam that Roger Smith went on. And he may at that point have been afraid of taking the physical because he wouldn't pass it. But there's also another theory, and that theory is that Jose Menendez was talking about, seriously talking about, how Mary Louise Menendez appeared to want to poison the family. You may remember the testimony of a young woman excuse me, named Tracy Baker. Tracy Baker, who was a friend of Lyle Menendez's for a very brief period, like a month, who went over to their house sometime in November of 1988, who was asked to stay for dinner, and then something really weird happened. And what happened was Mrs. Menendez brought out the food. Mr. Menendez looked at the food. "What are you trying to serve me? What's in this?" he said, and ordered the boys and Miss Baker out of the dining room, left the house, went out to eat. Now, he seemed suspicious of what was in the food. He was acting as if he believed she had put something in there. Now, both Erik and Lyle testified that their mother had threatened that she would poison everyone in the family, And they both testified that their father seemed to take these threats very seriously, and that there were a number of times when he'd get up from the dinner table because he suspected that the food was poisoned. Now, what's interesting about that from our perspective, from the perspective of how did this impact Erik Menendez's perception of his mother and whether she was a scary and dangerous person. And that's this. I don't know if she was really trying to poison the family, and I don't know if Jose even thought she was, because if you remember, he had this wicked sense of humor. He liked playing practical jokes. One of our witnesses, and I think it was Carlos Barral, but I'm not sure, or Terry Barral, said that Jose thought it was very funny, for example, in a social setting or at a party, to tell people that someone else that they knew at the party, for example, his wife, had cancer, and then everyone would treat her peculiarly, and he thought that was amusing. And I wouldn't doubt that he would think it amusing and a way of keeping everyone in the family alienated from each other, because divide and conquer certainly was his way of running this household, and keeping the boys afraid of their mother and the mother excluded from liaison with the boys by pretending that he thought she was poisoning the food. I don't know which it is, but what I do know is that from the perspective of Erik and Lyle, they're seeing their incredibly powerful, strong father refusing to eat in that house under the guise that mom's trying to kill us all. And that makes mom dangerous to them. Now, the other component of this greed theory, and I guess I'm talking about, I think it's been completely discredited, but it so offends me that I want to continue to talk about it for another few minutes. And that's the notion that they killed their parents. Erik killed his mother and his father because he wanted to buy a Jeep. That's the basic notion. Or he wanted to buy a Jeep and a pool table. Or he wanted to buy a Jeep and a pool table and some furniture, because that's what he bought. Now, they also propose a theory that he wanted to hire a tennis coach, but of course he already had a tennis coach. That he wanted to hire a tennis coach full time. Well, that was so that he could have the soft life, no doubt, of training 8 hours a day, 7 days a week to play professional tennis on the international circuit. And so I cannot conceive that any of you would really believe that he would do that, kill his parents so that he could buy a Jeep, because there's really no evidence that he couldn't have asked his parents for a Jeep and they wouldn't have given it to him. I mean, they seem to be financially very generous with their children. No one testified that Erik wanted for anything. No one testified that he ever spent money on anything either. He didn't seem to be a high-priced kid. He wasn't running around in a fancy sports car. He wasn't running around with a lot of fancy clothes. In fact, the evidence is that after the parents were killed, he needed to buy a jacket. He didn't even own a jacket suitable to wear to the memorial service. So that brings us to the big ticket item, which is Lyle's purchase of the Rolex watches. And here's another place where I'd like you to be able to draw the line between Erik and Lyle. Don't get us wrong, I think it's very obvious that Erik Menendez adores his brother and idolizes him and feels very guilty that through his going to Lyle for help, they've both been in jail for 3.5 years and maybe in jail the rest of their lives. And I think he feels a great deal of guilt about that he expressed here, and he certainly expressed it in the tape recording that you heard, and he certainly expressed it to Dr. Vickery, and it's real. This was the idolized big brother, and I think something else that you may have seen, and I never know during a trial what you all actually see, because there's a lot of different places for you to look. But when Lyle was testifying about his life, Erik was hysterical. At the council table, and it got real bad there at one point where we asked for a recess. When Erik was listening to Lyle talk about Lyle's suffering and Lyle's pain and Lyle's fear, Erik became completely hysterical. When Erik got on the witness stand and talked about his own, he didn't. And there seems to be a very special bond there where Erik cares in some way, I think, more for Lyle than he does for himself, which would, of course, be the family tradition. But my point is this, that there's no doubt also based on his testimony that Lyle adores Erik, but Lyle was raised to be in the image of Jose Menendez, and he was raised as the first son. And as a consequence, he did some things that he regrets. He molested his brother, and he is sorry about it, and I don't bring that up as a judgment against Lyle, but I bring it up as one of the many ways how, over the years, Erik suffered for being Lyle's little brother. Suffered at Lyle's own hands. And Lyle was something of a bully to him when they were younger, but that changed. And that changed around the time they were teenagers. Early, when Erik was about 13. And then his brother, in this incredibly cold, uncaring family, was the only person in his entire galaxy, if you will, not just world, not just universe, the entire galaxy, who showed any regard for Erik at all. Any protectiveness, any love, any caring, any concern. And I think that was the bond that can never, ever be broken in this family, the bond between the two brothers. But it hasn't always been easy for Erik to be Lyle's younger brother. For one thing, Erik Menendez at Princeton Day School is the second Menendez. And along with, and it isn't that people didn't like Lyle, it's just that along with a Menendez brother comes the Menendez parents. And Lyle, having been through that school once, I believe Erik testified, when he'd get into classes with the same teachers, there was like already a negative energy because they had had Lyle, and along would come Mr. and Mrs. M with their incredible demands on the teachers. But if we fast forward now to 1988, to these theft offenses that occurred in Calabasas, that's where Erik takes the big rap. And both Craig Signorelli and Lyle Menendez get to skate on those two episodes of thievery. And Erik is the one who goes to juvenile court, and Erik is the one who winds up getting that against him on his record. Now, I want to make one comment about that, and I will return to talk about those crimes later. And that comment is this: Mr. Kuriyama did something really quite improper in his opening statement. We have a stipulation that defines for you all the facts that we agreed would be necessary for you to know to deal with those two prior acts, because they were not introduced, and you will have an instruction to that effect. They were not introduced to show that Erik is a criminal. You absolutely cannot do that in a court of law. That is one of the big constitutional no-nos, which is to say, well, since this person committed that crime, he must be a criminal, therefore he must be guilty of this crime. That is absolutely against the rules. The instruction that you will get will tell you, and you have to follow this rule, even though you might have to do some mental gymnastics to comply. The reason that that information about the Calabasas thefts was allowed in, and it says this in the instruction, was only because it would help you understand what got him to Dr. Oziel that fateful day, and what his relationship with his parents might have been like. Because there is discussion on October 31st, November 2nd, and on the December 11th tape about what Jose and Kitty Menendez's reaction to Erik and Lyle having participated in those theft offenses, what their reaction was. And I think that's very important and interesting information, how the parents reacted to that. And when I talk a little later about this component of Erik's upbringing, which demonstrated his parents' corruption and immorality, I think those two offenses become very important. But the bottom line is, Lyle being the number one son, Lyle being the one upon whom all of Jose's demands and expectations were placed, Erik gets to take the rap alone for those theft offenses. So here we are in this trial, and you can hear on that tape of December 11th that there is a marked difference between Erik and Lyle in the way they express themselves. And I want to caution you about something, and it's very hard to talk to you about things you don't know about, because I can't tell you about things you don't know about. All I can do is tell you there's things you don't know about, and here's what they are. You recall in this case, Erik testified in front of you for some separate stuff, and in front of the Gold jury and this jury for much of his testimony. The same is true of Lyle. He testified in front of both juries for most of his testimony, but then just in front of the Gold jury for some parts of it. And you remember that I put on 3 expert witnesses, Dr. Tyler, Dr. Burgess, and Dr. Vickery, to talk about who Erik is, how things happened to him affected him, and you heard their testimony. But you did not hear the testimony of Lyle Menendez's expert
Counsel, let's
witness.
confine ourselves to what the evidence was in this trial.
Okay. My point is, what I'm concerned about is that you make certain judgments about Lyle that then spill over to Erik when you don't know everything there is to know about Lyle, because you're not his jury. You're only Erik's jury. And this brings me back to what I was saying in the very beginning. You have to judge Erik based on who he is and what he did and what you've heard about him. I say that because, let's take a look at, let me go and get at my other notebook if I may. Mr. Kuriyama's little opening. I don't say little to diminish the skill. I only say little to diminish the size because he's going to come roaring back, I'm sure, tomorrow for a much longer time than his opening. One of the idiosyncrasies about a case like this is that in a case where the defense puts on, and we put on 10 times the evidence that the prosecution did, in a case when the defense puts on a lot of evidence, the prosecution gets to use they get two chances at final argument. They get their opening, which he just did, and then they get what's known as their closing. The defense always gets only one argument. Now, in the usual case, when only the prosecution puts on a lot of evidence, the prosecutor's opening argument goes over his whole case, and then if the defense has put on any kind of case at all, they wait, let the defense counsel get up, talk about their case, and refute the prosecution's case, and then the prosecutor comes back and talks about what the defense has said about their defense case. That's how it works. But when basically almost all the evidence in the case is the defense case, what happens is what's going to happen here. The prosecution can sort of hold all their cards and wait until I'm done, and then get up and make a much more extensive argument. And then, to my eternal frustration, I do not get a chance to get back up and refute what he says. So that's the reason why I'm going to talk much longer, because I have to do it all in one shot. And he's going to have his chance again tomorrow. Now, I was trying to refer for a moment to the fact that he referred to Ed Fenno having heard, and it's unclear from who, and it's pure hearsay, that Mr. Menendez had to make this huge amount of restitution. And the other evidence you've heard in this case is that that huge number has to do with the total value of what was taken and not the amount that was paid for restitution, because most of the property was still there and returned. Now, what I was going to point out to you is how Mr. Kuriyama's argument was really an argument more properly made against Lyle Menendez. I noted in the thing here, Lyle. Okay. First of all, in trying to talk, he was trying to talk about how bad the brothers were the last year, the bad brother year. And the difficulty for him there in talking about Erik is there isn't anything about Erik after these theft offenses that occurred in July of 1988. Erik didn't do anything bad. He didn't give his parents any reason, any rational, normal reason. I mean, Mr. Kuriyama got up here and actually talked about these people as if they were Ozzie and Harriet versus the bad seeds. And that's not what this family was like, and you know that. However far you may or may not be willing to go in accepting how bad the abuse was, these were not normal folks. This was not a normal household, and they didn't raise totally normal children, which is what you would expect. Okay, but in talking about this so-called bad year, he's trying to find things, he's trying to find that somehow, well, I'm not sure what he's trying to do, you know, because he can't possibly claim that all of a sudden in this year these boys transmogrified from or Erik changed from who he essentially and always was to become this vicious, cold-hearted, mad dog killer. So, I guess playing on the assumption that you don't know enough about Lyle will make Lyle the vicious, cold dog killer and make you simply assume that Erik's the same as his brother, which not a single soul who testified in this court ever said was true. They are not alike. They may have both suffered, but they are not alike. Okay, so first he talked about what Uncle Brian said, and I'll return to Uncle Brian much later on other issues, but he said that, he talked about Lyle talking back to his, strike that. He said that Lyle and Erik talked back to their mother. And then, of course, he was completely unable to give us any example of that whatsoever. Then he quoted Carlos Baralt saying Lyle talked back to his mother. Well, Lyle talked back to his mother from the time he was 14. I'm not going to go through the entire defense in Lyle's case, but Lyle had a very poisonous relationship with his mother. This is the mother, I want to remind you, who wanted, when this child was 6 weeks old, to leave him full-time with her in-laws and visit on the weekends on the way up to the ski resort on Friday and the way down from the ski resort on Sunday. That was the testimony of Mary Louise Menendez's very best and dearest friend ever, Faith Goldsmith. So Lyle and his mother had a relationship which started out with rejection and got worse. And he testified that at the point when he stopped what he felt was this weird sort of sexual thing with her, that she became even more hostile towards him than before. And other people have testified. She was incredibly hostile and rejecting of Lyle as a baby, of Lyle as a teenager. Ed Fenno talked about how she would accost him, and that was Mr. Fenno's word, accost him every single morning as he's going through the breakfast room. She would jump on him, start a fight. So Lyle talked back to his mother. No one was ever able to give you one word that Erik ever said in talking back to his mother. But you know what? This whole issue about talking back just amazes me. We were all teenagers, weren't we? And some of us even own a few teenagers or post-teenagers. We have kids. Now, do you want to equate a teenager talking back to a parent with being a homicidal maniac? Because that is the strongest evidence of aggression that they think they have in this case. That these two youngsters talked back to their parents. Now, no one's been able to tell you that it was a talk back that wasn't deserved, or that it was a talk back that wasn't absolutely ordinary, but if my mother had said to me in an endless stream, as Mary Louise Menendez said to her kids, idiot, stupid, dummy, can't you do anything right? Try harder, swim faster, do more, you won't be a Menendez, you're dishonoring the family. You tell me you don't have a right to say, Mom, stuff it. And yet this is considered some critical piece of negative evidence that they talked back to their mother. Now, the interesting thing, as I say, though, is that only one witness says that Erik even did that to her. One witness, and it's her brother, Brian, who could not give us a single incident. I think he said, finally, stretching, gee, maybe in 1986 in Canada, she wanted him to go somewhere and he didn't want to go, so he was saying no. Well, did he go, Uncle Brian? Oh, yeah, he went. Disobey. No one's ever said disobey. Defy. Refuse to go along with the program. Talk back is the biggest sin. And let's talk about since I'm diverting now, I'm going to do this because I find this very hard to organize, I'll tell you. This particular case, everything seems to lead to everything else, so we'll freely associate here. I want to just turn this around. I know it's going to disrupt, but it just seems to me that we have to get a little perspective going here. You know, a case like a family is like a little universe. It's a closed system. Reality becomes what's proven in court, and that's not what's real. That's what becomes the operational reality in a case. And therefore, certain things get distorted, and you sort of have to be brought back to earth. So here it is, folks. The ultimate sin. Shut up. This is Erik Menendez's greatest crime prior to August 20th, 1989. And this is supposed to be proof that he is a killer. Because he said once in his life, when he is 18 years old, to his incredibly overbearing father, who was harassing him on the tennis court in front of everybody and making him crazy, he had the effrontery to say, shut up. Now, when you consider what Jose Menendez, and forget about the sex for the moment, you consider everything else Jose Menendez ever said or did to Erik, okay? They are making this huge big deal out of the fact that he said shut up, when to me what's incredible is that people remembered it. Pat and Brian remembered it. because it was so out of character that Erik Menendez would even say at 18 to his father, "Shut up." And it must have been a very scary experience for him to say, "Shut up" to that man. Now, I will tell you that if you don't give a child the right to stand up for themselves, if you so take away their sense of identity, terrible and drastic things can happen, just like they did in this case. And I'll seg you into just a little private recollection, which we are permitted to do here. When I was 12 years old, my mother did something that she had never done before. My mother was, may she rest in peace, she died during this trial, in fact. My mother was a very good person, but she had a very bad temper. And she used to use her hands a lot. She was a hitter. But when I was 12, she got really worked up about something, and I don't remember what it was. I must have been lippy. I had a right to talk back. That was one of the things. My mother was very liberal in children having certain dignities and certain rights, in spite of the bad temper and in spite of the hands and the spankings. So when I was 12, I must have said something that set her off, because she got really upset, and she reached into the closet and she took out a wooden suit hanger, you know, one of the, like, men use with the pants part, and she hit me with it. Now, she had never hit me with a weapon in my life. And I am 12, and because of how I was raised, I was truly affronted that my mother would hurt my physical person that way. She could yell and scream all she wanted. We did that in our family. And she could be as angry as she wanted, but to assault me physically was beyond the pale. And I did something that was the scariest thing I think I have ever done in my life, and it still scares me to think about it. I grabbed that hanger out of her hands, and I hit my mother with that hanger. And I was really frightened after I did that, because I had violated one of the big rules of nature. You do not hit your mother. Now, I never thought up until that point that my mother would kill me, but I sure thought when I hit her with the hanger that she would. However, my mother was a normal person, and as a consequence of my having hit her with the hanger, my mother never hit me again, in any way, shape, or form. Because even though we couldn't really talk about it, how offended I was, how insulted I felt, she got the point that you don't brutalize your children that way. And that was the end of that. But it was very scary for me to do something like that, to stand up to my mother. And I can imagine that that shut up cost Erik a lot before he had to pay the price for it later on in the hotel. That it cost him a lot at the moment it was said. And the fact that both Brian, who certainly didn't come here to do Erik any favors, and Pat remembered it, tells me that it was a truly unique experience in the life of Erik Menendez. That shut up. And that's as bad as it is. That's the worst thing anybody can say he ever did to his parents before he was driven over the edge. Now, Mr. Kuriyama also quoting Lyle in Erik's case, said that Mark Heffernan said the brothers were mad at the mother. That's not what Mark said. He never heard Erik say anything bad to his mother. He was attributing that solely to Lyle. And then we move on, and the worst, most egregious example of using Lyle to try to convict Erik here is the December 11th tape. Now, I'm very confused about what the prosecution position is with respect to Dr. Oziel right now. It is very clear when this case began, he was the entire centerpiece of their case. He was, and he is, what they need to prove that this was a premeditated, planned killing in order to end parental control, or for hatred. That was his two little constructs that they still seem to be somewhat buying into, at least the control part. But do they really expect you, at this stage of this case, after everything that's gone on, to believe Dr. Jerome Oziel beyond a reasonable doubt? I don't think they believe for 1 minute that you're going to do that. I have never seen a witness as destroyed as Dr. Oziel. We got him from every possible direction. His own voice on the tapes that Judalon Smith made, where he is making fun of the Menendez brothers, who he claims he's in such fear of, where he is showing that he was not trying to get rid of this woman. She was not pursuing him as he claimed. I mean, maybe I'm too cynical. But from the minute he sat here One of you is telling me, yes, I'm too cynical. I don't think you can ever be too cynical. Too paranoid, yes, but too cynical, no. The minute he sat here and said to you, in that totally self-assured style of his, that he had to tell Judalon Smith, because she was this crazy lady who was chasing him, and he couldn't get rid of her, I thought we had escaped beyond the looking glass, because that was the single most irrational piece of evidence I had heard in a court of law. He had to tell her because he was trying to get away from her? Right, Dr. Oziel. And of course he denied that he had violated the most basic tenet of the psychotherapist rulebook, which is reveal patient secrets in advance. He denied he did that. He denied she was in his office that night, ready to listen in to the private confidence of Erik Menendez, his patient for a year, who you would have thought he might have had that much sensitivity or loyalty to, but where it became very clear he had absolutely none. This is the depressed and suicidal kid, undisputedly so, who he never treats for suicide, who instead he pumps for details with which he can blackmail him for the rest of his life. Remember, Judalon, he says on tape, there's $14 million involved here. Well, there weren't really $14 million involved, but that's what he thought. I mean, from the beginning. You know, and we cross-examined the heck out of them, because you don't run from the Dr. Oziels of this world, you front them off, you face them down. And here is the witness where we brought in character witness after character witness, these women who seem to know him real well, who are telling you that he is the single most dishonest person they've ever run across in their life, as if you didn't already know that. But if you didn't already know that, here are other people to help you know that. But what is confusing and puzzling to me about Mr. Kuriyama's case, whatever it may be, is he is actually arguing in favor of the credibility of both Dr. Oziel and Judalon Smith, and that you cannot do. They are definitely a one or the other proposition, because she makes it very clear what a manipulative, lying, two-faced, agendized, if you will, a guy with a million agendas of his own, that man is. And she says flat out, I'm there and I'm listening, and he says, no, she's not, and there is no way to reconcile those two people. And what she says in this courtroom, and look, we certainly did not go out seeking Judalon Smith to intrude herself into the life of Erik Menendez. She got him arrested. She's the person who went to the police. She is the person who got that search warrant issued. She is the reason he is in jail. No, the reason he's in jail is because he killed his parents, but she's the reason he got arrested when and how he did. Okay? So this was not someone that the Menendez brothers sought to have in their life. In fact, Dr. Oziel wasn't even someone they sought to have in their life. He was another great choice of mom and dad's. But the fact is, and so I don't want to argue her credibility because it's too complicated. I mean, I think clearly there are times when she did not tell the truth in a very big way about whether she heard the Menendez brothers saying things or was merely told by Oziel what they said, because she has told two completely inconsistent stories about the heart of the matter. And I don't know which one is true, frankly. I don't know which one is her real story, but she doesn't belong to me. You know, I didn't create her, and she doesn't belong to me. She belongs to Dr. Oziel. He brought her into this whole mess. And I guess the way to analyze this is, which one of them would you rather have a cup of coffee with? I mean, it boils down to that. Because clearly, you're not going to send anybody you know for therapy with Dr. Oziel. That's clear. And I guess the best thing that, you know, Judalon's a very personable, very friendly, bubbly, pretty lady. So I guess the choice is, which one do you want to talk to? And that's the one you believe or don't believe either one of them. But the bottom line is, you can't believe them both. You can't take, as Mr. Kuriyama tries to do, I think I'll take this little part that helps me from Judalon and that little part that helps me from Oziel, and forget about the fact that they call each other massive liars. One thing I do know, Judalon's tapes, forget about what she said about what she heard about the Menendez brothers and what she did and didn't hear. The tapes that she made, calculating woman that she is, definitely show that Dr. Oziel lied to you about both his attitude, about what he said to her, about how he talked about Erik and Lyle on a huge number of issues. And it's right there in tape. And Dr. Oziel, after all, is a person who was had his license on probation at the time he first started seeing the Menendez family, all the way through all the times after the shooting of the parents. He's got new complaints filed against him. He's engaged in known criminal conduct for which the district attorney's office managed not to file on him. The same people, the same office that Mr. Kuriyama belongs to, where he got up here this morning and argued that you should accept Judalon Smith's word about something or another, is the office that refused to accept her word to prosecute Dr. Oziel for rape when she brought her complaint based on all the horrible things he had done to her. They weren't going to do that. Now, why? Well, this is a real fundamental issue. This doesn't have to do with do they like Dr. Oziel. This doesn't have to do with do they believe Judalon Smith. This has to do with the fundamental desire to convict the Menendez brothers. This has to do with whether or not the prosecutors in this case really evaluated evidence because they were interested in truth or because they were interested in winning. Your Honor, I'd like to take a break at this time and return to that theme.
All right, we'll take a recess and we'll resume at 10 minutes after the hour, ladies and gentlemen. Don't discuss the matter with anyone. Don't form any final opinions about it. We'll resume at 10 minutes after.
If all these props block, but I'll try to move them as soon as I can. I started to talk about before the break what I think is obvious based on Mr. Kuriyama's argument and things that were done during the course of the trial, which is this desperation that developed in the prosecution to try to put on evidence sufficient to convict Erik Menendez. And that desperation was revealed in Mr. Kuriyama's opening when all he could talk about apparently was Lyle and the things that Lyle had said. And he went through talking about things that Lyle says on the tape of December 11th that he considers as showing a plan. But the point of all this is that is Lyle talking, and you're going to receive an instruction, which I have, but I don't want to dig it out right now, but it's an instruction that is entitled Adoptive Admissions. And it talks about when you can take what one person is saying and use it against another person. And it lays out that the only time that you could find that the things that Lyle are saying you can use against Erik, as if Erik had said them, is if these things are accusations aimed at Erik, and if they're said in a situation where if they were not true, he should have said, no, I didn't do that, or no, that's not true. And it's our position that with respect to this tape recording that Dr. Oziel makes, which he turns on when he feels like, and it runs out in the end, this is not the kind of setting, for many reasons, that some of which you know about, some of which I'll talk about in a minute, Erik should have been expected to refute if Lyle was saying things that weren't true. For one thing, they weren't going to tell Dr. Oziel the truth. So this wasn't a session in which the truth mattered. This was something that was being done to keep Oziel placated because he had been making very suspicious suggestions to Erik and to Lyle concerning his interest in their money, concerning his nervousness, concerning his need to be placed at ease by them. And the fact that Erik took those signs of Dr. Oziel seriously and that he understood that Oziel was potentially threatening to blackmail him, which is clearly what he was up to, is reflected in the testimony of David Morovich, if I'm pronouncing it right. That was a friend of Erik's from New Jersey who he met in Cancun. And in Cancun, and this is right after the November 2nd session. This is long before even this December tape is made. And Erik tells his friend David when they're in Mexico that he doesn't trust his therapist. He thinks the guy's interested in his money. He doesn't understand what his agenda is, but he doesn't feel he can really talk to him. So this isn't a session that was meant to elicit truth. I don't know where Mr. Kuriyama thinks Judalon Smith ever said they made this tape in order to show remorse. That's not, no matter how inconsistent she's been, she never said that. And if you want to have all of her testimony reread, such fun, for that purpose, you can do it. You can ask for any testimony to be reread if it's important to your decision making, if you don't feel your notes are adequate, and if there's any kind of issue to be settled among you. In any event, what Mr. Kuriyama does is he seizes upon these things that Lyle says and never really mentions not only what Erik says during the 12/11 tape, but his entire demeanor. Dr. Oziel even testifies that when Erik first comes to him, he is in this really bad emotional condition. I mean, one of the things I'd like you to keep sort of like a little balloon hanging over you for a while, at least while you're indulging me and listening so attentively, is this. If Erik Menendez is such a horrible person that he would kill his parents because of A, B, or C, whenever the prosecution figures it out, they'll fill in the blank. If he's such a bad person, if he's such a vicious killer, why is he so distraught afterwards? Immediately afterwards. Now, I know about Mr. Kuriyama and his acting theory. He took a drama class in high school, therefore he acted to Detective Edmonds, therefore he acted when he was hysterical during the 9/11 call, and he acted when the police came. But I mean, was he acting from the time he was 2 years old? Was he acting when he was this very crying, very frightened, very anxious child? He's such a great actor. How come I couldn't get him on the witness stand to act? Would have been useful if he had been a little more emotional. He was so frightened and so cranked down, you hardly saw any feeling at all in him. But this is their great theory, that he's acting. So I guess he's acting on the 12/11 tape, and he's acting when he goes to Dr. Oziel, and that's nonsense. For one thing, on behalf of all the actors of this world, acting is not lying. Acting means you're in touch with emotions, and you can bring them out when the situation requires it. I mean, that's part one. But part two is Erik was described all of his life as a very sensitive, very anxious, very emotional person, okay? And because he was that kind of person, after he did this to his parents and got arrested and wound up in jail, he was nearly on the edge of a psychotic break. Because he was a sensitive person, because a cold and vicious person wouldn't have been in that condition that Dr. Vickery saw him in, wouldn't need medication to get through, wouldn't need medication to testify. There just is a difference between a cold person and a humane and sensitive person. And the kind of crime that Mr. Kuriyama claims happened here is not the kind of crime that a person like Erik Menendez could commit. And that keeps coming through. Even when the most betraying of all people in the world, Dr. Oziel, is on the witness stand, he cannot deny the fact that Erik came to him because he was in extreme anguish. Okay, he was falling apart, he was cracking up, he was feeling guilty and remorseful to an extreme degree for what he did to his parents. And that comes through from Erik, the person on trial here, in the 12/11 tape. However, Lyle deals with his issues. And when you examine the instruction on adoptive admission, you will realize that those things have to be kept segregated as to Lyle. But even if they're not, I mean, they went in there planning to lie. But in any event, Erik is silent during all this time that Lyle is saying these grim things about plans. And Oziel, of course, wanting a double blackmail, wants to get Erik's voice on this tape talking about the killings. So you may remember, or yeah, sure, you remember 5 months worth of everything, but maybe you don't remember. But when Dr. Burgess was on the witness stand the second time around, in talking about the meaning of this tape, or at least what she takes out of this tape, it's for you to decide what it means. I mean, this is the point, by the way, when you're the experts. It doesn't matter what anybody else has said in this trial. You have absolute, total power, finally. Okay, this is right at the end of Dr. Oziel's speech, in which he uses the word control and controlling to describe Jose Menendez 13 separate times. And neither Erik nor Lyle, during this entire tape, ever use that word. This is an Oziel word. And this is the proof. This tape is the absolute proof, in my opinion, that Oziel made up the story that he testified to, that he claims the brothers said to him on October 31st and November 2nd. He's the only person talking about control. He's the only person talking about hate. He's the only person saying negative things about Jose Menendez. But at the end of his control, and here's one of them, and there's another one, and it goes on, he tries to get Erik involved. And Erik is very emotional. He doesn't want to hear bad things about his parents. He starts to cry, and what he says 3 times in this one paragraph is, what I did because I had no choice. Now that is not a plan. Throughout the post-shooting contacts with Erik, he keeps letting out hints, his own set of cues and signs about the truth. He does it with Sergeant Edmonds. When he goes in there and he talks about smelling the smoke, when obviously there is no smoke when they come back at 11:45. The smoke is at the time of the shooting. He's giving himself away. When he talks in September to Detective Zoller, And he talks about, when I was young, I couldn't hurt a living thing. As you get older, life gets colder. He's telling them without telling them, because he is a person with a very active conscience, and it's killing him. And he's trying to let out. He is the confessor. He does give a sort of confession to Craig Signorelli. Not, I would submit, the one Craig came in here, he whose future is somehow wrapped up in this trial. Not the one he testified about, but he clearly told him something, okay? But my point is, this is what Erik is like on that tape. He cries, and he talks about no choice, and he talks about secrets, and he talks about not being able to talk to his parents, not being able to tell the truth. And he's doing what he does all along, which is constantly giving hints of the truth. Now, it would have been nice. I mean, I would much rather be in a trial right now on this case where Erik Menendez had been arrested at the police station by Sergeant Edmonds, and I wouldn't have to deal with the Oziels and the Judalons and the Craigs and all the other self-promoters who have been involved as witnesses for the prosecution in this case. It would have been clean and neat, and I would have much rather heard Sergeant Edmonds, who seems like a real nice guy, his version, with his tape recorder, thank you, of what was said that night, because Erik was on the verge of confessing even then. He can't keep his mouth shut when he's highly emotional and upset. He's sitting there in the police station. Sergeant Edmonds has his tape going. I would have, if Edmonds had just picked up on the clues, if they had just done the gunshot residue test. Mind you, I do not blame the police department, but it would have been a much nicer case and cleaner and had real issues and the focus on the real issues if we didn't have to litigate the Oziels and the Judalons and the Signorellis and the meanings of tape. It would have also have been nice, but could not have been part of this case, if Erik and Lyle could have simply, boom, told the truth way up front, sorted this all out, would have been in trial a long time ago, would have been much nicer. Why couldn't they do that, though? Because when children are raised in an environment where lying is the family rule, and it's the family rule because the minute you have a big secret to keep, you learn to lie. There's no way to keep a secret except to lie. So when you're raised in a family where lying is the operational principle, and when in this particular family other kinds of lying are actively encouraged, lie about your grades, lie about your abilities, lie about your accomplishments, lie about the perfection of our family. This is what they're being taught to do by their parents, okay? And when you're in this kind of family where your parents are so intrusive and so controlling, the only way you can have any kind of personal dignity, like me and my mother in the hangar, for example, but they don't have that kind of dignity in this family. They can't talk back to their parents in this family when they're little and when they're growing up. That's why it's so notable when they do it at all. But my point is, every person needs to feel, to whatever degree they're brave enough to assert it, that they're an individual, that they have rights as a person. And Erik testified, and Ed Fenno testified, and Lyle testified, that when they were teenagers, when Erik was 17, 18 years old, he lied to his parents to keep some measure of privacy in his life. This is a mother who's tapping his phone. This is a mother who examines his genitals until he's 15 years old. This is a mother who apparently stole his diaries. These are people who are so involved and intruded in their children's lives. The only way those children have any kind of separation is, I'm not going to tell them where I'm practicing tennis, and I'm not going to tell them what girls I'm interested in, and I'm not going to tell them those minor details. And that's a way, it's manipulative, yes, but it's a way to preserve some sense of yourself. So they learned through their whole life, for various reasons, how to lie, and they learned how to be afraid to tell grown-ups the truth. Now, you've heard testimony from our experts that children who are abused, not just molested, but in other ways abused, find it very hard to trust grown-ups because they've been betrayed by grown-ups, find it very hard to tell what's happened to them. That's any child who's been abused in any abusive family has that in common. In this family, though, the notion of not trusting people was taught as an affirmative lesson. You might remember the story that Carlos Barral told that Lyle also told, that Erik doesn't remember. Of course, he could have lied about it and made up that he remembered it, but he didn't. About him being encouraged to jump into his father's arms. And he was encouraged to do this repeatedly. And then at one point, Jose just didn't catch him, and the kid crashed to the floor on his face. And his father said, "That will teach you not to trust anyone, even your own father." And it was a good lesson in that family, not to trust your father. But when you do that to a little kid, they never trust anybody. So yes, the Menendez brothers lied after they were arrested. And that has made our life, lied rather before they were arrested. And that has made our life as their lawyers and their life as the accused much more complicated. But there is a theory that permeates the prosecution here, which is not based on reason. And that theory is, once you lie, you can never tell the truth. And that's not true. Even people, even kids who were raised to lie in certain circumstances can tell the truth. And it's our position here, and you are the judge of credibility, that Erik Menendez told you the truth about why these killings occurred and what happened in his background. Now, mind you, you have a right to be skeptical of people who have lied. You'd be a fool not to do that. And that is why we put on all those family witnesses with all those little tiny details that might have seemed extremely stupid to you in a murder case when we first put them on. You know, what does this have to do with August 20th, Mrs. Bozanich kept asking. And the point was, what it had to do to bring in the family members and the teachers and the coaches and the friends and anybody who had information was to show that what Erik was testifying to was not a lie. His family really was this sick. It really was a dreadful and strange place to grow up. And I couldn't expect you to accept just his testimony on that, because he has clearly lied to other witnesses who were going to be involved in this case. So we put on a lot of witnesses in order to corroborate, to confirm anything and everything that we could. Now, we had the naked pictures, and they were there, and they're still there, and they're still, as Dr. Burgess testified, the strongest corroboration of the molestation. And we have Erik's cousin Andy, who also corroborated it. And we have other witnesses who corroborate other aspects of the weird behavior in this family, in the hopes that you will then understand that even though someone has lied before, and even though, yes, his life is on the line, he is not lying to you. And the best method, you know, in a trial setting to determine whether someone is lying or not is to cross-examine them. And what's interesting here, of course, is that, as I said before, Erik was not cross-examined about the most important aspect of his maltreatment as a child, which was the molestation. They just want to ignore it. Just don't make him repeat it. Oh, God, I don't want to hear it again. Well, you're going to hear it again, because I'm going to tell you about it in a little while. All right, so therefore, where that gets me back to is, that's right, they're not being honest with Oziel, but, you know, Oziel isn't honest, you know, with every breath he takes. So it's sort of a fair match. Would you trust Dr. Oziel? And whether you would or not, they came in here and they told you what they were lying about and what they were not lying about. And to me, what's most important about the December 11th tape is how Erik sounds, what he's saying, and what he's suggesting in the things that he does say to Dr. Oziel. This is the page where he starts talking about how he loved his parents. It doesn't matter what they actually were. He's not interested in this evaluation of them. This led up to the fact, now this isn't a plan, this is a series of events where I had no other choice. I would have taken any other choice. I realize what people are worth. I regret it. I may not have had a choice at the time. I regret it. And then I think he says one more time, he was someone talking about his father, this idolized person in his family, and almost had no choice to do what I did, and I hate myself for doing it. And I don't think there's anybody who could say that he doesn't hate himself for doing it, and that the kind of person who would hate himself for doing it didn't do the kind of crime that the prosecution in this case wants to convince you was committed. But we were talking desperation, and the fact that they're trying to make you think that it's Lyle on trial here is part of their desperation. And this is the most desperate move of all. This is Detective Valentine. Now, Mr. Kuriyama makes a big deal out of the Big Five, and this is the Big Five in Santa Monica. It just overblows. Erik Menendez is on the witness stand for 10 days. He is not the wellest duck in the world, and you know that from Dr. Vickery. He has one of the worst backgrounds I'm sure any of you have heard about, and he is sit there and grilled day in and day out by Mr. Kuriyama. And in the course of all of that grilling and drilling, it really wasn't anything Mr. Kuriyama did. It was simply the fact that they found out that the Big Five stopped selling handguns in '86, that they were able to confront him with anything at all. Okay, and I'll show you where Mr. Kuriyama is exaggerating what he thinks he got with Erik Menendez on the stand. But 10 days, all right? And they were not able to prove that anything he said was actually a lie. Maybe he exaggerated that contact in the store, but I'll get back to that a little bit later when we talk about credibility. But then the prosecution goes, at the end of their case, their first rebuttal witness, and puts this perjurer on the witness stand. And what's so offensive about putting Detective Valentine, NYPD, on the stand is they know he's going to lie. They put him on knowing what he's saying cannot be true. Why? Because, as this limousine record would show, and as we know from testimony anyway, Lyle Menendez is on his way to Los Angeles in this foolish effort to do something with the home computer on the morning of August 31st. He catches a 6 o'clock flight. He's at Newark Airport at 5:50 in the morning, and they know he's flying back here. You may not remember, Mr. Kuriyama talked about the Haymans, which is the husband and wife, the pregnant lady and the husband computer people. But there's another computer guy, Howard Witkin. Howard Witkin's at the house early in the afternoon with Lyle Menendez, where Lyle is having him erased. Remember, the disc does get erased. Gets erased the day before, gets erased by Howard Witkin. Lyle Menendez is in the house. He had to get from New York to Los Angeles, and the Concorde doesn't fly between New York and Los Angeles. So he's flying out of Newark on a Delta flight, and the flight leaves at 6 o'clock in the morning. And Mr. Kuriyama and Mrs. Bozanic know darn well Lyle is here in Los Angeles and in an airplane.
Overruled, you may continue.
On an airplane getting here from the early morning hours. Okay, but what they put this guy on anyway, knowing he's not going to tell the truth, to testify that he saw Lyle Menendez at the U.S. Open the next morning, among his many other lies, and I'm going to take you through them now. I call Mr. Valentine, there's a certain category of witness in this case that is created by that infernal contraption in the corner. We oppose televising this trial. And the reason that defense lawyers generally do not want trials televised is because you get, particularly the way this one's been televised, you get what I call the volunteers. People who want their 15 seconds of fame, who want their face plastered on everybody's television set from New York to Los Angeles, and who listen to these trials and then pretend to have evidence to give in the case. They do their little research, watching what other people say, and then they roll on in here for their place of glory. Valentine is one of them. Grant Walker is another. Miss Pisarcik is a third. I will assume that Miss Browers is just extremely confused. But let's start with Mr. Valentine. I have a few pages here because page after page of perjury is relatively unusual, even in Los Angeles County trials. I'm going to swing the mic around so the evil eye can also hear. Now here is the story that Mr. Valentine tells, that on the Wednesday night before, the 30th, he reports to the Sheraton Center Hotel, and first he goes to the U.S. Open, he can't find anybody there, but down at the bottom of the page, he reports to the Sheraton Center and he, quote, finds the clients. If I read this small version, then I don't have to block the big version. I finally found the clients, he says on line 28. And on the next page, lots of objections. I learned that, I find the clients, who did you actually come in contact with, he says. Lyle Menendez. Now this is at the Sheraton Center Hotel Wednesday night. Now they know they're going to call Pat Heffernan as a witness in order to testify that she loaned her American Express card to Erik. Okay? They're in touch with her. She's going to be a witness in the case. This is not a mystery. this man is claiming that he sees Lyle at the hotel, and he goes on. He says he sees the girlfriend. Now, this guy's been watching TV because there's been lots of testimony up until this point about Lyle's got this girlfriend, Jamie Pisarzik, on and on. Okay. They're going to call Mrs. Heffernan. They put this guy on to say these things. They've talked to Mrs. Heffernan. They know they're not true. Mark Heffernan has already been a witness in this case and is then recalled again. They know this is not true. They are putting on perjury, this is known as, lying under oath in a big way. So he says he sees Lyle. He sees Lyle's girlfriend. Mrs. Heffernan testified, no way, Lyle's not there. And he even goes so far as to describe the girlfriend as looking like me. No, thank you. And she's a lot younger. And then he says he spends the night sitting outside, and then he goes to breakfast. And then where do they go? They go to the U.S. Open, right? Now, you may remember it's not an item of evidence here for technical reasons. But Mr. Kuriyama asked Mr. Valentine, there was this pay sheet of some kind, this record, which indicated what he had done, because he gets paid for hanging around on chairs in hotel room, outside hotel rooms. And this is supposed to be the record of his activities while he's bodyguarding Erik Menendez. And he looks at this record, and yes, it refreshes his recollection as to how many hours he spent with him, but gee whiz, golly gosh, it's wrong, because it doesn't show this early morning trip to the U.S. Open. Yes, it doesn't show it because he didn't take it, but he claims it was a mistake on the form. And the form, unfortunately, is not a piece of evidence, but his testimony about it is. If you have any doubt about it, you can hear that testimony. But here he is off on his fantasy trip to the U.S. Open by limousine in the wee small hours of the morning. And he and Erik and Pat and Mark Heffernan supposedly go to the U.S. Open. Pat testifies, no way, she went shopping, and Mark went to his lecture. He was there for a seminar. All right, but Detective Valentine tells you that they all drive off to Flushing Meadow to go to the U.S. Open. He goes into detail. He's asked, about the arrangements for the limousine, on and on. And he's asked, the limousine driver drove you to the U.S. Open? The U.S. Open. How far is it? 15, 18 miles. And once you got there, who was there? Why, Lyle and his girlfriend are there. Now, Lyle is apparently astrally projecting himself from the airplane that he's in, flying to Los Angeles to meet Detective Valentine at the U.S. Open with Jamie. Anyway, he says he goes to the U.S. Open, and then he goes so far as to say he also accompanies Erik to LaGuardia, but now he says they have to go back to the hotel after the U.S. Open, and then they go to LaGuardia. And that's what he says here. No, we had to go back to the hotel. And he gets to such detail in his lie about the U.S. Open. First, when I take him on cross, he talks about actually watching tennis matches, and they were female players, and he wasn't sure if it was doubles or singles, and they went in the back way, and they didn't have to pay. And they were in the stands, but first they went to the practice courts, and on and on and on, heaping lie upon lie upon lie upon lie, with a straight face. And then he says, of course, that they then go to LaGuardia Airport, and on the way, they have to make these stops at these computer stores so that Erik can get a program for his computer. Now, it is clear Detective Valentine's been watching the case. And it is clear he's here to help the other detectives, the ones who were actually assigned to this case, and to help the prosecution. Because his evidence doesn't even make any sense, but he obviously hasn't figured that out. No one claims that Erik did anything to the computer or tried to erase the will. By the time Erik gets back to Los Angeles, Mr. Whitkin's already been there. He's already done whatever he's done. It isn't even an issue. But it's just to make Erik look dirty. It's just to make him look like he has some interest in what's on the computer. It's just this desperate effort to make this basically good kid look like the vicious killer Mr. Kuriyama needs to create to get the conviction he wants. So here is Valentine talking about stops at computer stores, okay? And he's elaborate. He gets out. He's got a bodyguard. Now, I start to point out to him, of course, that you're not going to find too many computer stores on the long leg of this journey from the 59th Street Bridge to LaGuardia. You're going through some really bad neighborhoods in Queens, in New York, industrial and low income, and there just aren't any computer stores. So, of course, he then shifts and says, oh, it was in Manhattan. And it's real easy to park in Manhattan, go and cross down to the bridge early in the morning to go into these computer stores. It's as easy as our flying pig. But what's more important is this record here. And Guy DeLisio came and testified about it. It's sitting right there. This is not a secret, this document. This document is available and is shown to Valentine on the witness stand, and of course shown to the prosecution first. And obviously there are no stops at computer stores. There's no trip to the U.S. Open. This is what I mean when they say they know they're putting on a liar and they just don't care. Because here is the proof that he's lying. That plus the records of his own work, which doesn't show this trip to the U.S. Open. But that does not, deter the prosecution in this case. So then he goes, he finishes telling his lies about the computer store and claims the limo driver stopped. You heard DeLisio say if he had made a stop, he has to note it, and he remembers they didn't make any stops. And what's really shocking about Valentine is I tell him, Detective Valentine, we already know you're not telling the truth here. We know Lyle's on the airplane. We know he's in Los Angeles that afternoon. Now, don't you want to sort of fix your testimony? Oh, no. I'm definite. I saw Lyle Menendez at the U.S. Open that morning. And, we show him the record. Oh, well, I don't know how to read this record from the limo driver. And, and this is a very different reaction. This perjurer is a very different reaction than what happened when Mr. Kuriyama confronted Erik. With the fact that he had obviously either exaggerated or misconstrued the conversation in the Big Five. Because what does Erik say when he's confronted with the fact that handguns weren't sold there? He says, I must have been wrong. I must be mistaken. I must have misunderstood the conversation. Or it must have been another store. And you will remember when Erik, he's on the witness stand and he's talking about the fact that in June of 1988 his mother bought a rifle. And this is a rifle that we know still exists because Carlos Barral gave it to this officer Martinez to transport here to California so that they're now here. But in any event, his mother buys that rifle in June 29th, 1988, and she buys it at a store called Best Products. And here is the receipt, and there is her very distinctive handwriting. You will see that you can really tell what is Mary Louise Menendez's handwriting, and she signs the receipt for the purchase of the rifle. And I show it to Erik on the witness stand. He says that his memory is that he and his mother went to Sports Mart. So I'm showing him the receipt for Best Products. He says, but it wasn't Best Products. So he's insisting it isn't Best Products. It's clearly the receipt for the rifle. He's not real good on what places he's been in and the names of places. And we hadn't even heard at that point the testimony we later heard that when he was tested at the Lewis School, this happens to be a particular problem of his. I think it's called dysnomia. He gets the names of things wrong. He gets the names of places wrong. And I don't think that we knew that at the time he was testifying about the rifles, and we certainly didn't know that at the time he was testifying about the Big Five. But when he's confronted with the fact that he is wrong, that what he said can't be true, he admitted it, and he tried to explain what might have been wrong with his memory. But not old Andy Valentine. No, he insisted that it doesn't matter what evidence we have, he is telling the truth. And of course he told the truth about nothing except that Erik was taken by a limousine, which I proved through Guy DeLisio, to LaGuardia Airport that morning. And the Valentine's not important in any great cosmic sense, but he is important to the extent that you rely on the representations made by the prosecution in this case because their intentions aren't good. This is supposed to be a truth-seeking process, and that seems to get lost sometimes in the contest aspect, and this one was hard fought, and that does happen. There's no excuse for ever putting on a witness like this, but there is some excuse for some of the contest. And let me give you an example if you want. You heard a lot of things that you didn't need to hear, that aren't going to help you decide this case, that were just wound up in the long run to be noise. One of the reasons is, in the beginning, the prosecution thought they could prove certain things that it became very clear to them later they couldn't prove because they weren't true. Things about the Menendez family, for example, things about the parents. And so there was this whole long thing about keto. Now, I mean, we had a few laughs about keto, but the point of putting on Mrs. Hertz, and this happened when I wasn't here, the day that I wasn't here, but I've read the transcript, obviously. Mrs. Hertz, who's that little blonde lady who was a teacher at PDS and a friend of the Menendezes, was called to testify and did testify to something that other witnesses have talked about, the fact that Kitty Menendez was acting very peculiarly in August, specifically August 1st, 1989. Now, we don't put on evidence that Mrs. Menendez acted peculiarly because we think that she deserves to die because she's peculiar, or to make her look bad. The whole point of all of this is to try to make you understand, what did Erik see in his mother? What is she to him? Why does she ultimately become as frightening, if not more so, a person than his father? And unfortunately, people who who are sort of in charge of your life, people who are the grown-ups, people who you have looked up to and look to for guidance, when they go off, it's very scary to kids. It's very alienating and it's very scary. And even at 18, you can still be a kid in relation to your mother. And we just put that on to show that she was acting quite bizarrely in August of 1989. And it struck Mrs. Hertz as strange that Kitty would bring up in the middle of a completely unrelated conversation the fact that she was soon going to be traveling to Quito, that she had relatives there. And it was strange because she had never heard it before, and she's from South America, so she thought she would have heard it before. So she thought it was peculiar. Now, at first, and during Erik Menendez's cross-examination, for example, the prosecution's position was Mrs. Hertz got it wrong. This wasn't Quito, Peru, which of course we know doesn't exist. It is Ecuador. This is Kalamazoo, which is in Michigan. I mean, this is nonsense. But this is how things can get distorted just through the adversarial process, if you will. And Mr. Kuriyama is determined to prove that Mrs. Hertz was wrong and it's really Kalamazoo. So he has Erik Menendez on the stand, and while he's cross-examining him, he asks Erik, now you don't even have relatives in Quito, Peru. What does Erik know? These are parents who never talk to him. How would he know where he has relatives? He says, no, we don't. And then the same prosecution calls Brian Anderson to testify that yes, they do have relatives in Quito, and yes, she was planning on and on and on. All right. The only thing significant about the Quito statement is that it's completely out of context when it's made. She's telling Alicia Hertz she's going to go very soon. Brian Anderson claims she's going to go in the winter. That's that. But a lot of heat and light is sometimes spent on things for no good reason, but just for the fight. And that's what concerns me. How much of what the prosecution argues here is just for the fight, and how much of it is the search for truth. Now, I've talked to you about circumstantial evidence. In order to find that what happened here was a first-degree murder, you have to find what the prosecution so desperately wanted from the discredited Dr. Oziel, which is a plan. Because without a plan to kill, the only evidence that they have that is at all ambiguous is the purchase of the guns 2 days before. And that is circumstantial evidence that points two ways. Either they're going down there, as Mr. Kuriyama argues, because they want to conceal that they are buying guns because they're planning to kill their parents. That's a series of inferences. There is another set of logical inferences, that they are going to San Diego because they're going to San Diego, or for any reason, or to buy guns. That yes, they don't want their parents to know they're buying guns, given the fact that they're afraid. I mean, this is just, if you just accept for the moment the defense theory, the going to San Diego is not inconsistent with it. That they use false ID, not because they're trying somehow to hide, although hiding the fact that they're buying guns does not necessarily prove. It's just a circumstantial evidence fact. It doesn't prove they're planning to kill their parents, any more than it disproves that they're planning to defend themselves against their parents. And you wouldn't want these parents to know, let's assume hypothetically the parents are in fact planning to kill them as they believe. Okay, let's just assume they're right. This is what they believe, this is what the parents are doing. You wouldn't want them to know you're about to make plans to defend yourself. You're just going to bring them down on you all the sooner. They'll just find some other way to get you. They'll make sure you can't defend yourself. So you don't want them to know you're going to San Diego. You don't want them to know you're buying guns. But the fact of the matter is, with respect to the use of Donovan Goudreau's driver's license, just happened to be the only driver's license they had on them. Lyle's was suspended. The records are in evidence. Erik's, he had lost. His tickets for driving without his license, for having lost it, his DMV record, is in evidence. That's totally corroborated by government documents. You don't get better than that. Okay? So they didn't have a license. They had Donovan's, which he left behind, which Erik picked up because he needed an ID to get into clubs, and he used it. I mean, it's that simple. And the prosecution wants to make a big deal out of the fact that it looks like such elaborate planning to use a fake ID. And it would if he had used a fake ID that couldn't possibly be linked to them. But the whole reason, I mean, all of this evidence, including, this is the photograph of the Big Five in San Diego, about the Big Five in San Diego was developed by the police because they used an ID of someone intimately linked with Lyle Menendez. So they're not, for example, they could have used, if they had been planning, the Richard Stevens ID that Erik had obtained. This was an ID in a completely false name, and although it had his picture, the way you run a check on something is you run the name, obviously. So Donovan Goudreau was a name that meant something to the Beverly Hills Police Department, but Richard Stevens wouldn't. He doesn't exist. He's a made-up person. So if you're really trying to hide, and if you're trying to negotiate a transaction surreptitiously with no trouble, aren't you better off using a license that can't be traced to you by name, where it's got your own picture so it can't even be questioned? But they don't do that, because that tells you they weren't planning at that point to buy these guns. They don't use the more logical, truly fake ID that they have. Moreover, it's interesting. I wonder if the Big Five in San Diego has changed their equipment, because everything that goes on in this courtroom is known. There was testimony. Here are the surveillance cameras that look over the gun counter at the Big Five in San Diego. And the notion that they're buying these guns based on this elaborate, thought-out plan to avoid detection, and yet they're in a store that has surveillance cameras, and they don't know that they're fake. Detective Zoller testified that he discovered in talking to the people at Big Five that their surveillance cameras are fake, but there's no way to tell that if you're a customer. I assume they want you to believe, if you're a customer, just the opposite. And so the fact that they pick a store like this rather than some little place where there isn't any surveillance cameras also tells you they're not really thinking this through. And the point of this is, you're either looking at a plan or you're looking at panic. You're looking at people who are desperate and are scrambling to prepare to defend. Now, preparing to defend is not the same as a plan to kill. And the easiest example I can give you is if you're living in a neighborhood, for example, where and I think I gave this as a hypothetical to Oziel as well. You're living in a neighborhood that's been hit with a rash of burglaries, and you become nervous about it, and you decide, as many people do, that you want to protect your home. So you go out and you buy a gun. Now, are you planning to kill a burglar? No. Have you considered that you might have to? Well, obviously you're buying a gun. And if you're buying a gun and you're a rational person, you must be thinking on some level, I may have to use this gun. Otherwise, it isn't going to protect you very much in a tight spot. But there's all the difference in the world between planning to kill somebody, planning to kill a burglar, and preparing yourself to defend yourself. But from the outside, it looks exactly the same. You go and you buy a gun 2 days before the gun is used. Is it a plan? Is it preparation? It is a piece of circumstantial evidence, and it is subject to the rule that I read to you before about how to interpret circumstantial evidence. The other thing in analyzing, is this a plan? or is this panic and preparation? Is this? If it is what Mr. Kuriyama wants you to believe, a thought-out plan to kill, they didn't want any more, I don't know, control. I don't know, like I said, they hated, they didn't want control, they wanted the money. Whatever the theory may be, what's the hurry? This is the part that they have never addressed. If this is a plan to kill, why can't they wait 2 weeks to get handguns, which are quieter and therefore less likely to be detected? And if you're gonna plan, obviously, the whole point of a plan is to A, accomplish what you're planning, which is bring about the death of someone, if you're planning to kill, and B, get away with it. Okay, that's the whole point of a plan. As Dr. Burgess testified, that's the whole notion when the FBI does their analysis of crime scenes, and they're trying to figure out, is it planned, is it not planned? Planned to avoid detection is what that means. So if you're planning, and it's obvious you could either buy a nice quiet handgun or a great big booming shotgun, why would you ever buy the shotgun? Well, the answer is when you cannot wait. And when can't you wait? When you think someone's trying to kill you now. But if all you're doing is deciding, well, it's been 18 years and I think we've had enough of this stuff now, so I think I'll just off the folks. There is no reason why you have to do it that weekend. There's always going to be 2 more weekends or 3 more weekends. And I suspect Mr. Kuriyama will come back with some notion, oh, but Lyle was going back to college. Oh, but Lyle lived on airplanes. I mean, everybody in that family was in Princeton or in Los Angeles every other week. So that just is, and moreover, we don't know when Lyle was going back to college, when Lyle was due to be there. We've heard something about his mother having to be there to help him furnish his condo, the one that they bought from, that the parents bought for him, somewhere in mid-September, that the condo was closing escrow somewhere around September 9th. But it's not like they weren't coming back. It's not like if this was really something that the two of them needed to accomplish or wanted to accomplish, that they couldn't have waited 2 weeks to arm themselves with something that would not have woken half the neighborhood. So the very fact that that there is haste involved tells you it isn't a plan. Mr. Kuriyama says, oh, they're trying to conceal it because they don't use the credit card. They're trying to defend themselves against the people who get the statements on the credit card. I mean, do we understand this? And they're not sure. I mean, if they really were planning to kill their parents, they would have used the credit card because the parents would have been dead when the statement came and they wouldn't have known. They wouldn't have figured it out, right? But the fact is, they're not really planning to kill their parents. They're planning to defend themselves and hope it doesn't come to that. Either way, it doesn't make sense to use you can use the family credit card if you're really planning to kill them, but if you're not planning to kill them, you might have to explain that to Pop. What's these 2 shotguns in San Diego, son? You don't want to have to do that, not with Jose Menendez. Now, the other thing when we focus on the gun purchase, which is their strongest piece of evidence, I mean, this is as strong as it gets about planning, is the purchase in San Diego. But if they're really planning to kill these people, and this is thought out, and this is weighed and deliberated, and I will get to show you the definition of first-degree murder, it requires real thought and choice. It requires deliberation, just like what you're going to go in there and do, deliberating, weighing, evaluating, all of that. If that's really what's going on, how come they can't figure out to buy the right ammunition right off the bat? Now, Miss Geyer, and I have a flip chart that features her as well, testifies that in August, it's the beginning of the game hunting season. And so the Big Five has got stacked up in the center of the store all these boxes of ammunition for hunting, which is game load ammunition. I bet you didn't remember that. I remember that. And I showed Detective Van Horn. He took a part for you. He was the sheriff's detective who had the shotgun and was showing you how shotguns worked and patterns and that stuff. A game load of the same brand of ammunition that Detective Van Horn said was used here, and he could tell the brand because of what was left over, the waddings that came out of the shell casings that were still at the scene. He knew it was this Italian brand, which is Fiocchi or Fiucci, I'm not sure how it's pronounced. And it's game load, and that's what Mrs. Geyer said was at the store, and that's what Lyle testifies he picks up on the way out. Don't even have a discussion about what's the proper ammunition if you're really determined to kill somebody. You just pick up what's on the floor. And I think there are other pictures of the store that show that there's ammunition behind the counter that they could have inquired about if they were really thinking at that point that absolutely they're going to have to use these guns to defend themselves. But what ultimately happens is they go back home Friday night, and then the mother tells them the time of the boat trip has been changed, and because they are paranoid, having been raised in fear, and they are fearful because of these things that have happened that week and the confrontations with the father, then they get scared even more. So Saturday morning, they go off to buy, well, Erik, first of all, when you talk about a witness, by the way, who's lying, Erik tells more bad things about himself that you wouldn't have known about if he didn't get on the witness stand and tell them than any witness I've ever seen. But he testifies that Saturday morning, they go to a gun store here in Van Nuys that Detective Zoller confirms exists, that he describes accurately, okay? And it's called Gun World, what's it called? The Target Range in Gun World, that's what it's called. And this is a place that has a firing range, and he picks it so that he can go there and fire the gun because he doesn't know how to use it, and he's worried now, seriously concerned that he's going to have to use it, and he wants to practice, and he admits all that. Now that's, you could take that and make something out of it as a prosecutor. Aha, he wants to make sure he gets his aim right when he kills his parents. You could argue that, but this is information that Erik is giving you that they didn't know about and could never have proven. But they go that morning, and they buy the bigger ammunition. And you hear this from Erik Menendez and from Lyle Menendez. And you hear Erik's purpose is to practice, and Lyle's purpose is to make sure they've got the right ammunition because they are more frightened now. But the point of all this is if they really were planning, they would have planned to find out about ammunition at the 3 previous gun stores they went to. Whether it was the Big Five in Santa Monica or somewhere else, no one's disputed that wherever they went didn't sell shotguns. It's shotguns, it's just handguns that they supposedly didn't sell. And so they could have bought it there, I suppose. They could have asked about ammunition and options. They testified that when they went down to San Diego, they went to a smaller place first and talked about shotguns for protection, but they didn't buy there because they were being so uncertain. They were afraid they were attracting the suspicion of the owner. And then they wind up in the Big Five in Santa Monica, and then they wind up at the Target Range in Gun World here in Van Nuys. 4 gun stores. Now, prosecutor could argue, my goodness, isn't that evidence of planning? They're absolutely determined to get this ammunition and these guns and off their parents. But all of that information came from Erik and Lyle Menendez. All the prosecution knew about was that they bought at Big Five. So why would they lie to make themselves look bad? Why would they say I went to the Big Five in Santa Monica or a similar gun store if it wasn't true? Why would he say we tried to buy handguns? Because what does that tell you? I mean, handguns aren't even as good for self-defense, frankly. You know, a shotgun stops people. But that's what he testified to because that's what was going through their little heads that day. They had very little experience in the world, these two. And they are now running around together in this panic. And they are giving up this very negative stuff about what they're doing. And there was no reason to tell it, let alone lie about it. Okay. Now, apart from this one piece of activity before the actual shootings, the other evidence, physical evidence in the case, all of which is circumstantial evidence, definitely demonstrates that there was no advance plan. We called Dr. Burgess to testify about this, but you really don't need an expert per se to tell you what's pretty obvious, okay? And it's got to be pretty obvious that that you would never, ever plan, if you had a choice, to fire multiple rounds from a shotgun inside a residence in a densely populated area. Now you saw, we did the videotape that we did of Elm Drive was for the purpose of showing you one thing. Not how pretty the houses are, how big they are, that's true, but how close they are. How close this house is that this family had lived in for nearly a year. And we showed you that to show if someone is calculating and planning in this premeditated way, they're going to realize you're going to shoot off these guns right in the, in a house, in a room that has almost a solid wall of French doors, right? And they shoot the guns in such a direction, they blow out the glass from the doors. That just enhances the transmittal of noise. And that's your big plan to avoid concealment, to shoot the guns off in this house? And I think there's been another one of these adversarial distortions here. The point is not that by firing the guns off, the point is not only that the neighbors will hear it and pick up the phone and call the police who are only a mile away. I mean, that's a large point as to why you would not plan that. But the point is also that somebody might go to their window and look out and see you leaving. You don't make noise because you don't want to attract attention. It's not just that you don't want to inspire people to call the cops. You don't want them to look. You don't want to attract attention in any way. So just the very fact that the whole purpose of a plan to avoid detection seems to be completely undermined when you buy these shotguns should tell you, therefore, that using the shotguns that Sunday night was not part of a plan to kill the parents and avoid detection. Now, also the fact, and Dr. Burgess testified about this too, the fact that if for whatever crazy reason, and I think through questioning, one of the prosecutors actually suggested in a question that you use a shotgun because you want everybody to hear you, because then you can set up an alibi. Yeah, if you get out the front door without being seen by everybody in the world, maybe you could set up an alibi, but that's another one of those Alice in Wonderland moments in the trial. Okay, but the point is, if you really are going to plan for whatever reason to use a shotgun, and this is something you're thinking about, then you're not going to use it in such a way that you then have to worry about hanging around later to pick up shells. I mean, the purpose of picking up shells from a shotgun, when you intend to dump the gun anyway, is to not leave fingerprints on the base of the shell casing. And you're going to have in evidence that shell that Detective Van Horn emptied here, so you can see what one of those look like. I've taken the gunpowder out so it's not dangerous. So it's got the birdshot, and it's got the metal base on the bottom of the shotgun shell. And yes, as you saw when I was loading the gun, you generally push the shell in with your thumb, and you can therefore leave a thumbprint. But if you're thinking things through, as the prosecution would have you believe, you wear a glove, and then you don't have to hang around while the neighbors look or call the police or both to pick up the shells. And the fact that they picked up the shells, that there were potential prints on the shells, is evidence of no planning. Now, the other thing that, to me, and I don't believe that Dr. Burgess addressed this, is evidence that there is not this plan. Let me say one thing about this notion about why this was done, to be free of the parent control. This sounds very nice, but what does it mean? It means you gotta hate these people bad enough. Don't tell me you're gonna kill parents you love to be free of their control. You have to hate them a lot to kill them to be free of their control, rather than free yourself some other way, okay? And if that's how you feel, and if you are planning this thing, one would think that you would load these guns to the hilt. Now, the prosecution they argue that the guns are fully loaded, and that's why there had to be a reload. But the physical evidence is completely contrary to that. Detective Van Horn testified to the number of waddings that were given to him by the Beverly Hills Police Department. And we will assume, since no one wanted to prove otherwise, that the Beverly Hills Police Department wasn't holding out on Detective Van Horn. They gave him everything. And the coroner's office had some waddings in their possession because they were included inside the wounds. So he had all the waddings, and what he testified to is there is only physical evidence of 8 rounds being fired. And 6 of them are buckshot, and 2 of them were birdshot, and the 2 birdshot wounds was the left cheek of Mrs. Menendez. We know this from the coroner, not from Detective Van Horn, and the left shoulder, neck, and ear of Mrs. Menendez. So that's all they can prove by way of evidence of how many rounds were fired, unless they now want to assert that these defendants, the great planners of the Western world, hung around long enough to now start picking up these little teeny bits of buckshot wadding, which is no more than you'll see it. It's just a little plastic disc, which is called an over-powder wad for the buckshot. There's this little teeny plastic disc, and now they're going to go hunting around in that room. These people who supposedly plan not to be detected and not caught, looking for these little waddings. So there's no evidence that they did, and it was never mentioned. I mean, Erik did talk about to Oziel the fact that they picked up the shell casings, but there's no mention of these waddings being picked up. And so there's really no evidence that more than 8 rounds were fired. Erik said he loaded his gun with 5, he thinks. And maybe he did. Lyle didn't remember how many he loaded his gun with. But the point of all this is that they did not load what they could have, which is 6 rounds per gun. There is no evidence that 12 and 1, 13 rounds were fired. Because if they had loaded fully 6 each gun, then there was the reload where 1 more round was loaded by Lyle, and Lyle shot his mother with it. And there just isn't any evidence of those 13 rounds. So in a way, the fact that they didn't fully load the guns tells you that this isn't really a plan. These are people acting in a panic who are grabbing shells and loading quickly and running in the house because of the fear that they have that they're about to be attacked. The other thing that indicates that there's, and this is again just circumstantial evidence liable for 2 inferences. If they're both reasonable, the law requires you to find the inference that points towards innocence. And it's just a chain. No one thing here tells you innocent or guilty. The other thing, though, that tells you that there was no real plan here of any kind is that there was no disposal plan that made any sense that was worked out in advance. For one thing, contrary to what Mr. Kuriyama tells you, testimony in this case, both the statement of Dr. Oziel and the statement of Erik, is not that he buried these guns. What he did was he slid them under some bushes down the side of a hill. And he testified he did not go down as far as Dr. Oziel claims. He just went down the hillside, put the guns down, brushed a little dirt and bushes, he said some kind of branches over it, and ran back up the hill. And Mr. Kuriyama has tried to suggest over and over again, as if this was a strangulation case, that Erik was a strong, aggressive athlete. I don't know what his strength has to do with anything. It doesn't take many to load a shotgun, and it takes very little to pull the trigger. I think it's just to make him seem like a big, nasty, aggressive person as compared to his little teeny-weeny parents. But the one place where the fact that Erik is a talented athlete makes some sense is his ability to get up and down a hill rather quickly. I mean, I think I've seen the place where the guns were dropped. I don't know. I'm going on the same testimony that Detective Zoller heard and the same thing that Detective Zoller told me. And as I questioned Detective Zoller about it, this location, it's a location from which the guns could very easily have disappeared afterwards because of this drainage culvert that runs down the side of the hill. But it also is because there's a drainage culvert running down the side of the hill. It isn't like you're working your way through a thicket in the jungle. You can get up and get down that hill rather quickly. But the point is, there's no plan here for what they're going to do with the guns. I mean, how do you know somebody's not going to come by when you're up on Mulholland doing this stuff and seeing you? If you're really thinking in advance, you're going to work something better than that out. Moreover, there's the fact that having not realized that, you're going to get fingerprints on the casings because they're not thinking in terms of avoiding detection when they're actually doing the shooting. They're thinking in terms of saving their lives. Nevertheless, had this been planned, you would think that they wouldn't be leaving some of the shells in the back of the car. And had they been the kind of people who could have cold-bloodedly killed their parents, they would not have been so disorganized, disoriented, and discombobulated after this as to have called the police with the car parked in front with shells and other evidence of their purchase of ammunition and shotguns still in it. I know that it's the prosecution's theory that at least Lyle Menendez wasn't truly upset afterwards and wasn't really distraught afterwards, but the very fact that that evidence was left there tells you that neither one of them was thinking rationally afterwards, because neither one of them was the kind of person who could do a thing like this based on some coldly formed plan. The other reason why there's no evidence here of a plan is because they had no alibi. They didn't even have the appearance of an alibi. If they really had planned in advance rather than grabbed for some idea afterward, that they would say they were at the movie theater, they would have movie tickets to prove it. They're easy to get. They give them to you. You give them the money, you get the ticket. You keep the stub, you show it to the police. You've had established some kind of alibi. Now, a movie is a very lame alibi anyway, because you can always leave. They don't lock you into theaters. And so it's not a very good alibi anyhow. But at least you've got a ticket, and this is supposed to be planned. Now, I know what Mr. Kuriyama's argument's going to be on this, and it's again, they don't want to deal with the evidence. They don't want to deal with all that defense evidence we put on. They don't want to deal with their own evidence. They would rather invite you to speculate because the evidence doesn't get them where they want to go. And I know what he's going to say. He's going to say, Erik put the ticket in the pocket of his pants, and when he threw the pants away at the gas station, he forgot he had the ticket in the pocket of the pants. Now, if he doesn't say that, he'll only not say that because I've ridiculed him for it right now, because he definitely asked that question of Erik Menendez in his cross-examination. And it's ridiculous. These are your cold, calculating planners. This is their alibi ticket. This is so important. You're going to forget them in the pocket of your pants? It's just guesswork. It's just guesswork. Guesswork to convict somebody of first-degree murder. Well, we can laugh about it, but it's sort of sickening. So there are no tickets in this well-worked-out plan. Just speculation about tickets. Moreover, the whole business with Perry Berman, the idea of having an alibi is so there is a human being who can say to the authorities why he couldn't have been there doing that because he was here with me doing this. That's the purpose of an alibi witness. Now, how in the world are you creating Perry Berman as an alibi witness when you tell him you're going to meet him at 9:30, you shoot your parents at 10, and you don't meet him? You tell him you're going to, and you don't meet him at 9:30. You don't even get there at 10:15. You don't get to where you're supposed to meet your alibi witness till 11:07. And what you have therefore done is exactly what happened in this case. You have created a witness for the prosecution who can definitely say you were not with him at the time of the crime. You have created an anti-witness, an anti-alibi witness, the opposite of what you would do if you were planning to create an alibi. So it is perfectly clear, I would think, that the Perry Berman arrangements that Lyle made was not an effort to create an alibi, but purely a social plan. Now, after the shooting, when Erik and Lyle are running around in the car trying to figure out what to do, that's when they decide, we'll say we were at the movies, and we'll say that we then went to the Taste of LA to meet Perry Berman, and we'll claim we got there much earlier than we got there, but we didn't see Perry. That's when the first idea occurs to them to try to use the fact that they had had a social plan with Perry Berman as an alibi. But they're not thinking very clearly, because obviously the police are going to go to Perry Berman, and he's going to say they didn't meet me when they were supposed to meet me, and that's about as big a red flag as the police should need. And they had that red flag, and they didn't do anything with it, which is the ultimate amazement. Your Honor, this is a good place for me.
Okay. It's 4:30, and we'll resume tomorrow at 9 o'clock. Ladies and gentlemen, don't discuss